passes. I will turn the gavel over to John Cora to preside over the final hearing in docket 18-16.
Okay. Madam Chair, we have the full council on the phone. Okay. Okay, very good. Good morning. I'm John Cora, and I'm the presiding officer in this matter. It's 9 o'clock, February 11th, 2019, and we are going on a record in docket 18-1601, which is Bentonite Performance Minerals, LLC, petition for order in lieu of consent. This hearing is being held in the basement conference room, B24, of the Hathaway Building on 2300 Capitol Avenue, Cheyenne, Wyoming. This conference is being transcribed by a court reporter. The petitioner, Bentonite Performance Minerals, is represented by Samuel Yemington and Matt Michaeli from Holland & Hart. And 2U Ranch is represented by Scott Erickson. Scott, are you on the phone?
Yes, sir.
Yeah.
Yes, I'm on the phone.
Scott, can you speak again? Scott, can you speak again, please?
I'm sorry, I cannot hear you.
Okay, very good. Scott, this is
No, Scott is here.
If Scott's there, he can't hear us. What he said. How's that, Scott?
Yes, I can hear you now.
Okay, very good. Scott, this is hearing John Cora, the hearing officer. And
Yes.
Did you hear anything in my introduction about where we're at?
I heard part of it.
Okay, let me just back up then a little bit. We're this conference is being transcribed by a court reporter. The petitioner, Bentonite Performance Minerals, is represented here in person by Samuel Yemington and Matt Michaeli from Holland & Hart. And the last thing I think I said was that 2U Ranch is represented by Scott Erickson. Is that
Correct?
Okay,
Yes,
that's correct. Thank you. Okay, I want to be able to direct questions regarding this matter to just one representative from each party. So, Mr. Yemington, Mr. Michaeli, who will be the first chair for your client? All right, Mr. Yemington. And then, Mr. Erickson, it's my understanding that you're going to be the only person representing 2U. Is that correct?
That is correct.
All right, very good. I'm going to go over how we'll proceed here. The process will be that each party will have 10 minutes for opening statements. And then it's up to Bentonite Performance Minerals. They have the burden of proving the statutory elements by the preponderance of the evidence that the EQC should issue an order in lieu of consent. Now, there are only two elements remaining that must be proven by Bentonite Performance Minerals today. The first two elements of that four-element test for an order in lieu of consent were decided in favor of Bentonite Performance Minerals on the summary judgment hearing that we had the other day. The two elements left to be decided are element C, which states that the use does not substantially prohibit the operations of the surface owner, and D, the proposed plan reclaims the surface to its approved future use in segments if circumstances permit, as soon as feasibly possible. So evidence and testimony offered by for any other purpose is not going to be relevant for this proceeding, and I urge both parties to stay focused on these two issues. Now, just a couple of words here about how I want to go forward with this. The first thing is we've got a court reporter here Mr. Erickson, that and we want to make sure that we don't talk over each other. So one of the rules for
Okay.
everybody is going to be that we have one person at a time talk. The other thing is that I'm going to ask both parties to be clear and specific as to the two elements that we are going to try to decide, that we will decide today, which is item C and D, as I just mentioned. If I think that we're straying too far abroad from that or not on focus, I will be interrupting you. Please, both parties, please understand that my job is going to be to stick to the knitting here and be efficient as we possibly can so that the council can make an appropriate decision. So I may be cutting some people off or interrupting you in order to get you to focus in on the point of your argument from time to time. So we're going to begin once BPM is, well, first of all, let me say that therefore we'll begin with our presentation of the evidence at the end of the opening remarks. That's when you'll be calling your witnesses, and we'll go through all of that. At the end, there will be a piece there where Bentonite Performance Minerals can have an opportunity to present any rebuttal evidence that you might have. And then from there, we can go to closing arguments. The council will probably take a little bit of a break somewhere in there, though, and you'll obviously be informed of that. I think previously to this meeting today, there were exhibits by both parties that were submitted. And right now I want to try to enter into the record those exhibits that are out there. So I'm going to ask each party, are there any, and I'll start with Bentonite Performance Minerals first. Are there any objections? If there any reason why we shouldn't accept all the exhibits? I'll start with Performance Bentonite and go to your round.
We wouldn't affect the admission of any of those to the extent they're used for relevant purposes.
Okay, very good.
I'm sorry, but I can't understand him.
You'll have to really speak up.
You'll have to just repeat that again.
You're pretty soft-spoken, and when we're on the phone like this, you might have to really speak up.
I'll certainly try to, and certainly remind me to the extent I don't. I'd appreciate it.
Thanks.
So I think we need to repeat that for Mr. Erickson.
Yeah, please.
Okay, yeah, certainly. Scott, for your purposes, BPM does not object to any of the exhibits that you've identified. We would withhold the opportunity to raise objections to the extent any of those exhibits are used for purposes that aren't relevant to the two remaining elements of the order in lieu of consent analysis.
Okay. So, Mr. Erickson, do you have any objections to anything that has been submitted so far by Bentonite Performance?
Actually, I do. If you look at their lengthy list of exhibits, negotiation correspondence, they're all dated basically prior to our receiving, as they claim, all the information on the proposed mining. So prior to September of 2017, 2U did not know what mining was going to occur. For instance, the trees, the wetlands, and everything else were going to be destroyed. So all those negotiations prior to that point were made with the assumption that BPM was not going to be mining trees, wetlands, mining viewscape, and so forth. So I think they're really irrelevant to this proceeding. I also have objections to basically the Jolly Etzel exhibits. Jolly Etzel is a separate mining permit, and it doesn't involve the state lease mining, and that mining was basically done and approved because it did not destroy any trees, wetlands, viewscape, and so forth, and it's really irrelevant to this proceedings. I also have an objection to hold on here, let me flip the page here. Let's see here.
Hey, yep, okay. Go ahead. Keep
Well,
proceed.
I'm sorry, somebody's breaking up in the background. I can't hear them. Where they have basically the discovery depositions, because discovery was done on Ronald James Erickson, and he wasn't authorized to speak for the Tootie Ranch. So that, again, is irrelevant. So I think that if we eliminate that, we can probably save the council a lot of hours of hearing this, because it's not relevant to this proceeding. It's not relevant to item C and D.
Okay, Mr. Erickson, would you please give me the numbers of the exhibits that you wish to, that you're objecting to?
Yes, it's under negotiation correspondence. It's BPM 5 through, hold on here, BPM 60. So all those from 5 through 60.
Jim, are they?
I'm also objecting to, it's under hitting Jolly Etzel. It's BPM 82 through BPM 90. I'm also objecting through for exhibit under trees, BPM 91 through 93, because it's irrelevant, once again, to the proceedings. I'm objecting to under discovery, BPM 94 through BPM 98. Once again, not relevant to this proceeding.
What was that last number again, Mr. Erickson?
I was under discovery. It's under BPM 94 through BPM 98.
Okay. Okay, well, let me do two things here. First, those exhibits not referenced by you then shall be admitted. I don't think there are very many as I look at this now, but anyway, of the other exhibits, I will hold off on admitting those until such time as they're actually used for evidence or used as part of the testimony. And at that point in time, Mr. Erickson, please refer to your list and remind the council if that exhibit is referred to by Bentonite Performance Minerals and restate your objection. And at that time, I'll rule on whether it's admissible or not.
Okay.
All right, thank you. All right, are there any questions as to how we'll proceed?
Hearing examiner Cora,
Yeah.
just one point of clarification. I understood you to say one person per witness. Is that right? So we have two witnesses. Mr. Emmington will do one and I'll do the other.
Okay.
Is that okay?
That'll be fine.
Okay.
That'll be fine.
Are we allowed to question their witnesses?
Yeah, oh, yes, yes, you will be.
Okay.
And they will be allowed to question yours. The sequence will be that they will, for example, they'll call a witness. You'll have questions for the witness. The council will then have questions, and then they will have a chance to redirect. And those four steps will take place when it's your turn to do that as well.
Okay.
Okay. So with that out of the road, I would like to start with the opening statements. You each have 10 minutes for your opening statement. We'll be timing that. So we will start with the petitioners, which is Mr. Yemington and Mr. Michaelai. Mr. Yemington, you're gonna deliver the opening statement?
I am.
Okay. We're ready for you. Go ahead and start.
Thank you. Madam Chair, members of the EQC, thanks for joining us today. My name is Samuel Yemington. We certainly appreciate you taking the time to entertain this petition for an order in lieu of consent. Today, we're here to do that, to consider whether BPM, the applicant for a permit amendment application, satisfied its obligations.
Mr. Erickson, can you hear that? Okay.
Yes, I can hear that.
Okay, great. All right, keep going.
Certainly. We're here today to determine whether BPM, as the applicant for a mining application with the Land Quality Division, satisfied its statutory obligations to involve the surface owner in the permitting process in developing that permit. And fundamentally, an order in lieu of consent is a procedural mechanism built into the Environmental Quality Act that allows the EQC and allows the operator to prove that they've complied with their obligations under the Environmental Quality Act, that they've engaged that surface owner, and that because they have complied, their permit can move forward through processing with the Land Quality Division. And so to better understand what our role is today, I think it's helpful to take a step back and to remind ourselves the legislative history and the legislative policy behind the Environmental Quality Act. And I think that by doing that and viewing this process through that lens, we're going to better understand both what the role of the EQC is in this process and specifically for this proceeding, and importantly, what the role of a surface owner is in the mine permit process under the Environmental Quality Act. And so the Environmental Quality Act was ratified by the Wyoming legislature in 1973. And in years following, they amended and modified it. But by and large, what we got in 1973 is what we're working with today. And what was the purpose of it? What was the public policy and the purpose of the Environmental Quality Act? Well, on one hand, it's fairly self-evident. The name itself lends to that purpose, the Environmental Quality Act. But we can turn to the statute because the Wyoming legislature told us exactly what the purpose and the policy was, because they ratified and codified that purpose and policy in Wyoming Statute 3511-102. And in 3511-102, the Wyoming legislature adopted a policy and a purpose whereby the EQA was designed expressly and explicitly to prevent pollution in the state of Wyoming, to preserve the air and the water of the state of Wyoming. And importantly, the third aspect for purposes of this proceeding, to ensure that land that's disturbed by operations such as those operations proposed by Bentonite Performance Minerals are reclaimed in a manner that allows the operations that were existing before that mine and reclamation operation to exist and to enjoy those lands after the mining and the reclamation has been completed. And so as part of developing the Environmental Quality Act, the legislature also tasked the Land Quality Division with overseeing and implementing a permitting process for surface mining in Wyoming. And importantly, as part of that process, as one piece of that process, the Wyoming legislature instructed operators to involve the surface owner at the beginning of the permitting process. And this is a fundamental change in how this was approached in Wyoming. And it makes sense though, right? The idea that if you involve the surface owner, you can better realize those fundamental goals of the Environmental Quality Act. With respect to surface mining, you can better ensure that those lands, by involving the surface owner, are reclaimed and repurposed to the highest previous use. And why is it? It's because the surface owner, of all people, would have the best and most informed position on how that land's been used historically and how that land can be used moving forward. And so there's absolute value there. There's absolute value in involving the surface owner at the beginning of the permitting process, using that information from the surface owner to ensure that that proposal, that mining proposal, the reclamation plans, the mining plans, that they take into account existing operations, that they don't substantially prohibit the existing operations from taking place while you're conducting those operations, and that they reclaim those lands to a future use that was the highest previous use by the surface owner. And so we understand how the Wyoming legislature approached this. And we understand how they made that public policy decision to involve the surface owner. What I haven't touched on is what the Wyoming legislature did not intend. And what they did not intend was to, on one hand, grant the surface owner a veto over a permit application. Top to bottom, the Environmental Quality Act provides no grounds for that. Second, the Wyoming legislature in no way meant to usurp the authority of the Land Quality Division and their permitting expertise and to hand that to the surface owner. The purpose of involving the surface owner is limited. Their role in this process is limited. They have a role, but it's limited. The Wyoming legislature intended that the surface owner inform this process, that they inform the development of a mine plan and a reclamation plan so it limits the surface disturbance, it accounts for existing operations, and it reclaims the surface in a manner that allows the surface owner to continue using it at the highest use he used it before. The Wyoming legislature did not grant the surface owner the right to veto a permit application or to hold the permit applicant hostage while they sought compensation and rewards for mining on their lands. So thank you.
That's it, Mr. Yemington?
Well, let me add one more thing to that. You're going to hear testimony today from two representatives of BPM. The first representative is Mr. Tyler Tatro. He's a rancher. He's grown up in the area. He knows the country. He's going to provide testimony on his interactions with the Ericksons. He's going to provide testimony on how he communicated with them, how he first approached them about this development, how he's worked with them in the past, and he will demonstrate that BPM has taken every effort to accommodate, not to just avoid substantially prohibiting operations, but to accommodate the existing grazing, logging, and hunting operations that they're aware of on these lands. And the second representative from BPM is Ms. Jen Hart, permitting expert at BPM. And Jen's going to testify about how this mine plan and how this reclamation plan were developed, how the Ericksons were included in that development, and why this reclamation plan specifically reclaims the surface as fast as possible. And because you'll hear testimony with respect to that, and you'll see evidence through exhibits with respect to those two elements of the order in lieu of consent, the EQC will be mandated pursuant to Wyoming Statute 3511-406 to issue an order in lieu of consent to Bentonite Performance Minerals so that their application with the Land Quality Division can move forward and can be processed. And so with that, I'll end my opening remarks.
Okay, very good. Thank you. You did well, 7 minutes and 40 seconds. So, great. Mr. Erickson, are you prepared now to give your opening remarks?
Yes, I am.
Okay. Please begin.
Well, first of all, good morning to the council. And let me kind of go over how we're going to approach that being the 2U Ranch. BPM kept referencing this Environmental Quality Act, which obviously this has been an issue that has been before the EQC before, back in 87 and 82. So this council has dealt with this before, and they have precedented rulings. And these precedented rulings have determined that they are responsible under the Environmental Quality Act, and they have jurisdiction over whether or not decide whether or not the previous use of the land is being restored back to its highest previous use. So this has been well established. And what they have ruled upon, yes.
Okay. Yeah, go ahead. Keep going.
Okay, you can hear me?
Yeah.
Okay. What they have ruled upon is that it's not the DEQ that makes the decision on the highest previous use. It's the Environmental Quality Council. And the Environmental Quality Council has, in some cases, ruled that If they cannot restore the land back to its highest previous use, then mining will not occur. If they did decide that the reclamation plan is deficient, then the Environmental Quality Council has, once again, a precedent showing that they have to go back and revise the reclamation plan. In this case, back in 1982, they have to plant trees. You cannot have a reclamation plan that does not include restoration of all the highest previous uses. The highest previous uses of this land is not just grazing. It includes things like hunting, viewscape, recreational, all sorts of wildlife habitat, the wetland spring. There's a horrendous amount of other previous uses. And the Environmental Quality Council has once again ruled previously on things like wetlands and springs and so forth. You have got to include it in the reclamation plan, and it has to be restorable. And we'll go over all the, in great detail, of all the reasons why you cannot restore this land back to highest previous use. But it's even more than that. It's going to basically impact the operations of surface owner. We'll go through and we'll show you how there will be loss of grazing revenue. We will show there will be a loss of hunting revenue. We will show that the ecosystem, the wildlife, will be impacted such that our hunting operations will be present and future negatively impacted. We'll show that you're going to, basically BPM is going to remove 11,000 trees. Well, that obviously is going to impact recreation, hunting, viewscape, habitat, and so forth. And we'll go on and show also that trees cannot be replanted in that not reclaimed area. It's well established that it's not physically possible to replant trees. We'll talk about impacts on recreation, impacts on any tourist income, and land values. The general rule of thumb is if you remove the trees, your land values go down by half. That will not only impact land values, but also what if we wanted to, needed to borrow against that as to put in our hunting lodge and cabins and such. Well, collateral for a loan would be severely impacted. We're going to go through and show you that there's just a overwhelming volume of laws and rules and regulations that DPM has to include reclamation plans for trees, wetlands, mitigation plans. And we're going to show that they basically are not above the law. They have to adhere to the law. If they adhere to the law, they're fine, but they haven't. There is mitigation wetland plans. We'll go through all this in great detail, but once again, the reclamation plan only includes reclamation of grazing. That is not all the previous uses of this land. It's well established. We've been hunting on that place for 40 years. We will also go on and show that not only that the previous uses are not being addressed in the reclamation plan, we're going to go on and show that it can never be restored ever back to the highest previous use for a very simple reason. You cannot plant trees in acidic, silty, high clay soil. They don't grow. It's not physically possible. So we're going to go through and systematically show that really the Environmental Quality Council should not issue an order in lieu of consent because they can't restore the land back to its highest previous use ever. And we're also going to show that it does impact our present and future operations. And also, as kind of goes when they're witnesses, we are going to talk about the fact that we requested back in April 5th of 2017, and we have an exhibit on this, that we needed all the information on how they're going to mine. They'd only provided us with things like a reclamation plan and mining plan. We did not know until September 2017, when they finally sent it about half a year later, when we got our hands on the wildlife, vegetative plans, and wetlands plans, what the level of destruction these guys were planning for this ranch. So all the stuff that Tyler and Jennifer and so forth are going to be testifying, and it's like I said, it's a zillion exhibits here. It's irrelevant because we did not know at that point when we were negotiating. We thought they were in the disturbed prairie, like they did before on the Jolly Etzel. They didn't disturb wetlands. They did not disturb trees. They did not disturb viewscape. So negotiation up to that point, we were in the dark. We were clueless. We were negotiating basically in good faith, thinking that this was going to be just a simple prairie restoration, not what these guys were planning in the mountains and the trees and wetlands and so forth. So I think all that really would be a waste of the council's time, quite frankly. So I'm thrilled.
Okay. Very good. Thank you, Mr. Erickson. That was a little over 7 minutes, so we appreciate the brevity.
Okay.
At this point, I think we're ready to go ahead and start. Mr. Erickson, excuse me, Mr. Yemington and Michael, would you like to call your first witness?
Yes, BPM would call Mr. Tyler Tatro as our first witness.
Okay.
And I will stay seated if that's okay with the EQC for purposes of the audio.
Yeah, I think that's fine. Mr. Erickson, they've called our first witness, Tyler Tetral, and so would you please state your name, who you work for, and also we need to take an oath. So you raise your right hand. Okay, so please introduce yourself, and Mr. Erickson, if you can't hear him, just let us know right away.
Okay.
My name is Tyler Tatral, and that's spelled Tetrault. I'm the Mineral Resource Coordinator for Bentonite Performance Minerals.
And Tyler, thanks for joining us. And just to remind you, please try to talk into the mic so everyone can hear, and then that may help address your answers to the EQC as opposed to me. So I'll try to do the same as well with my questions. Again, Tyler, could you introduce yourself as far as who you work for and what your title is?
Yes, so I'm the Mineral Resource Coordinator for Bentonite Performance Minerals. I started with the company in 2013 as a senior mine associate. During that time there, I handled some of the stormwater permits as well as assisting the permitting process. Then over time, I moved into the Mineral Resource Coordinator position, working with a lot of the surface use and mineral leases that we have for the Colony, Wyoming operation. We're located in northeast Wyoming, about 12 miles from the South Dakota border and 18 miles from the Montana border.
Could you tell me a little bit more background just about yourself?
Sure. I grew up just outside of a small town called St. Ange, South Dakota. It's about 17 miles from the Wyoming border. I grew up on a ranch there. Was homesteaded back in 1877. It's been a family's ranch ever since then. It's a cow-calf operation, and also have the pleasure of growing up with raising sheep as well. I attended college at Black Hills State University, where I played football and graduated in 2008 with a biology degree, major and a minor in earth science. After my career there, or after my time with Black Hills, I joined the Forest Service fighting fires and worked with cattle grazing permits in South Dakota and Wyoming before I joined the company in 2013. After joining the company, I decided to go back to school and get a Master's of Science of Sustainability. Black Hills State University.
And in your capacity of your position with BPM, you work regularly with both mineral owners and surface owners?
Yeah, we have roughly about 25 different agreements with surface owners and mineral owners. A lot of the stuff located in Wyoming is split estate, where the surface owner is not necessarily the mineral owner. So there's quite a bit of interactions with the different surface use agreements that we have. In mineral, we have minerals that we own as a company, as well as minerals that are privately held and minerals that are held by the state of Wyoming.
And in your role with BPM, have you interacted with, do you know the Ericksons?
Yes, interacted with them in the past.
And are you familiar with their lands?
I am.
Okay, and you just describe briefly their lands?
Yeah, so the lands that we have, we had an act mining on the Jolly-Etzel claims, as well as the State Lease 04 amendment. Prior history that I've seen on their operation is a cattle grazing and cow-calf pair operation that is leased out to a rancher nearby. They have seasonal deer hunting season, usually occurs in December, and then as well as some bentonite mining that's gone on in the past with us and other companies that operate on their surface as well.
Okay, and with that, I'd like to direct everyone's attention to what's been marked as BPM Exhibit 105. And if it's okay with EQC, I'm going to ask you to dim or turn off the lights and have Tyler use a laser pointer that he has to sort of illustrate his conversation. I know this is a bit small, so what we're going to do is try to magnify it a bit and have him walk us through what we're looking at. So why don't you start, Tyler? What are we looking at here?
Yeah, may I approach the screen?
Let me, that's, council, can you see enough detail there?
And are you asking?
I
can't see the detail, John, but I'll look at the exhibit.
Right, very good.
And we have provided a hard copy of this as well. I just know it's a little, it's a large map. So our hope is that we can zoom in a little bit and give everyone a better understanding of where we're at in the world. To the extent we can, we will, and then we'll move forward.
Okay. May I approach the screen up there? Maybe it might help. Okay.
Yeah. You just speak to around.
Yep.
Why don't we start in the top left there, in the northwest corner, and tell us what we're looking at.
So this is a map that shows the different service entities that the Erickson's own as well. Right here, this is our amendment about
Breaking up.
state lease.
Yeah, okay.
Speak up a little.
You're gonna have to talk
Okay.
way louder. You have a mic that will work, Joe?
Yeah. So this is a map that shows different service ownerships.
Let me just, were you able to hear that, Mr. Erickson?
Partially.
Can you move that, let's just pause for a second until we get this figured out. Can you move that mic closer to him?
We're gonna try. Is this better? You guys hear me?
Yes, I can hear now.
Okay.
Great.
So this is a map that's showing the different surface entities that the Ericksons have in relation to our permanent amendment boundary that's located right here, and then as well as our proposed disturbance for the state lease 04.
Mr. Hearing Officer, could I ask that when the witness points to something that looks like there's colored lines, if he can describe the color he's pointing to, that may also help people who are on the phone know where he's pointing to.
Yeah, so our permanent boundary is the red and yellow polygon line, and then proposed disturbance is that red hashtag that's located in the center.
All right, Tyler, why don't we start, and again, catch me, Mr. Erickson, if you can't understand my questions. Why don't you start here in the top left-hand corner, and Michelle, if you could just magnify that a little bit so we have a better idea what we're looking at. And then Tyler, if you can, to the extent you know, walk us through this and tell us what we're looking at.
So in the top left, what we're looking at here, inside the green polygon, that's what's known as the Four Horsemen Ranch.
I'm sorry, the what?
Four Horsemen Ranch. And as well, as you can see on the top left, there's another place called the Bullpine Ranch LLC, and that I believe is where all of their ranch buildings are located. Anytime we have a meeting with the Ericksons, we always meet on site at the Bullpine Ranch that's located right there in the little box. To access this property for the meetings, we always come from Highway 212. It's about, I guess, 24 miles coming from the top and coming down into that area.
All right, Tyler, moving a little bit further to the east and to the south. Just, again, describe what we're looking at.
So then again in the green, that is another portion of the Four Horsemen Ranch. This aerial is a 2017 aerial imagery. So the disturbance that you can see, that's not our company's, that's American Coal Company. They're actively mining on that area just north of our permit amendment boundary. As we move south, that's when you get into what was the 2U Ranch with our permit amendment boundary. And then the purple, I believe, is Cinquefoil, another Erickson company. And then the other one is Valkyrie, which would be another company owned by the Ericksons. As we move further to the southeast, this is where our Jolly Etzel mining would be right here inside this red boundary right here. The Jolly Etzel stuff, we were actively mining on the 2U Ranch and also known as the Sextus LC Ranch.
And to your knowledge, are the 2U Ranch and Sextus LC Erickson entities?
Yes, they are, to my knowledge.
And let me ask you this, when you started mining there in Jolly Etzel, and we'll get into this in more detail, were these entities in existence?
So when we got our first surface use agreement with them in 2007, it was under Lonesome Country Limited. It was the one company that we were working with. All those lands were covered under the Lonesome Country Limited, which was a service owner at the time, which were the Ericksons.
Okay, moving further, I see some purple boundaries, Clan LLC, Sextus again down here, the Erickson Corporation. To your knowledge, all Erickson properties?
Yes, that is correct.
And to your knowledge, all covered by Lonesome Country when you initiated mining on these properties?
Yes, we never had anything on the Erickson Corporation, but over here, the Sextus 2U Glam, that was all under the Lonesome Country.
Okay, and it appears, and maybe Michelle, you can grab this as well, it goes just a little further to the southwest. Again, Bull Pine, we saw this entity in the north. Is that the same entity?
Yes, I believe so.
And to your knowledge, is that entity owned by the Ericksons?
Yes, to my knowledge, it is.
And then Erickson Corporation, to your knowledge, is that owned by the Ericksons?
Yes, it is, to my knowledge.
Thank you. And you mentioned, just for purposes of the record, that this aerial photography was on what date?
2017.
Thank you. And Mr. Tatro, you mentioned briefly that you're familiar with how some of these lands have been used. Would you provide some additional testimony with respect to the existing uses of these lands by the Ericksons?
Yes. So the existing uses that we've seen on there would be the grazing with the Muleshoe Ranch, leased out to them running their cattle on there in the summertime, as well as the occasional deer hunting season in the month of November. Bentonite mining by us, and then American Coal as well takes place on this property. And there was a little bit of logging, I believe, for a temporary period of time as well.
Michelle, could you bring up what's been marked as a BPM Exhibit 95?
Mr. Erickson,
Yes.
recall that when you had argued about certain exhibits, you gave us a lot of numbers. I think.
Yes,
this-
I will actually agree to BPM 95.
All right, very good. How about 105? Just to kind of go back and make sure.
105 is fine too, yes.
All right, very good. Thank you. So just, yeah, so each time they come up, we'll go through this routine to make sure that we address your concern. Okay, go ahead, Mr. Henningsen.
Thank you, hearing examiner. Mr. Tatro, are you familiar with this document?
Yes, this appears to be the lease agreement between Lonesome Country LC and Muleshoe Ranch.
Okay, and just quickly, to your knowledge, do the Ericksons or any of the Erickson entities own or operate any cattle operations?
To the best of my knowledge, they do not own any cattle.
And returning to the previous map, we don't need to bring it up, but approximately how many acres do the Erickson entities cover?
I believe a ballpark number is about 8,400 acres.
Okay, and are you familiar with how many acres this grazing lease covers?
This grazing lease covers 6,335 acres.
And how do you know that?
Because it's in the second paragraph of the document.
Okay, and does the lease describe what lands that this grazing lease covers?
It just gives townships and ranges, but it doesn't describe specific sections within there. But based upon what we've seen with cattle graze, I would assume that it covers the cattle that graze on the state leased lands and Jolly Etzel claims.
Okay, and based on your understanding of the lands and your review of this lease, would you be willing to testify as to whether this lease covers the subject lands?
Yes, I would believe this lease would cover those subject lands.
And do you believe this lease would have covered the Jolly Etzel claims?
Yes, I would believe that as well.
Okay. And you mentioned existing operations of grazing underneath this lease, maybe some, I believe you said logging, is that correct?
Correct.
And did you mention hunting?
Correct.
Okay. Any other operations?
The only other operations out there would be just the bentonite mining
And-
by other companies.
And again, what are the other companies or company that operates out there?
So it's American Colloid is the other company that mines bentonite in this area.
And are they actively mining on Erickson lands today?
Yes, to the best of my knowledge, they're still actively mining on that Four Horsemen Ranch area that we looked at.
Okay. And let's talk for a few minutes about those Jolly Etzel claims and sort of the history of BPM's operations on those Erickson lands. Who owns the minerals of the Jolly Etzel claims? And I'll go ahead and ask Michelle to put up what's been marked as BPM Exhibit 81.
So the mineral ownership of the Jolly Etzel claims are minerals that our company patented. So just the bentonite minerals is owned by Bentonite Performance Minerals. Those are our minerals.
Okay. And I see what's been marked as Jolly Etzel 12, 13, 14, and 15. We're going to explain what that is.
So those are the claim boundaries of the mineral patents that we have in Jolly Etzel area. On that map, you can see as well that it's kind of tough to see, but there's identified as what the ore bodies would be. And with our mine plan, we're going to continue mining from the Jolly Etzels into the state lease 04 permit.
Okay. And what gave you access and the right to mine the Jolly Etzel claims?
Yeah, so we had the right to mine. Was permitted under a permit 267C, and then to access, we had a surface use agreement with Lonesome Country at the time.
Okay, but it's my understanding that Lonesome Country no longer exists and that someone else owns the surface. Do you want to talk about that?
Yes, so for the Jolly Etzel claims, Lonesome Country no longer exists. It's been dissolved, and it's been split up now between 2U Ranch, Glam, Sextus, and I believe that the Cinquefoil and Valkyrie is also located on part of some of these Jolly Etzel claims.
And again, to your knowledge, are all those entities owned by the Ericksons?
To the best of my knowledge, yes, they are.
And you spoke earlier about the existing operations that you're aware of, sort of on the entire ranch. Specific to Jolly Etzel, aware of any existing operations?
So the existing operations that we work with the Ericksons on would be cattle grazing. We work with them on getting reclamation fences around our mining, and then they also had hunting, rifle deer hunting season that took place in November. During that time, we stopped our mining operations per their request.
Okay, and if I look at what's been marked as BPM Exhibit 81, I do see surface disturbance. Can you talk about the sort of progression, the timing, the operators, what's going on out here, and what we're looking at?
Yeah, so within those Jolly Etzel claims,
sorry to interrupt. To the extent you want to use that laser pointer, it might be handy for
sure
you to describe them.
Yeah, so we had some mining activities in this bowl up here. This area has been reclaimed already. We started mining around this area as well as over here in the Jolly Etzel 15, and then we got a little bit of some activity going on in this area as well.
And could you discuss any other bentonite mining in and around the Jolly Etzel claims?
Yes. So American Colloid, that was the other company. They mined this area down here to the south. This has all been reclaimed, but this whole bowl down here was their mining from the past.
Okay, and I see what looks like some disturbance heading north. Is that a road, and if so, is it connected to bentonite mining?
Yes, so then the road that comes up through here, this black line right here, that's where we get into the state lease permit boundary, but this road going up to the north, that has been constructed by American Colloid for their mining operations up on the Four Horsemen Ranch.
And is American Colloid actively using that road?
Yes, they are. When they mine, they haul out this way, and they come down around over here and out to the southeast.
And approximately how far is this operation from your plant in Colony, Wyoming?
This is about 15 miles from our plant in Colony, Wyoming.
And developing these lands, these Jolly Etzel lands, for purposes of permitting with the Department of Environmental Quality, presumably you had to identify an existing and proposed use for those lands for purposes of your reclamation plan. Is that correct?
Correct.
And what did you identify these lands as for purposes of processing that permit?
For the Jolly Etzels, it was identified as grazing land.
Okay. And how did you come to that determination?
We came to that determination because it fits the definition of grazing land as well as those uses on the land with occasionally with cattle grazing going on the property with wildlife in the hunting season. So that's why we identified it as grazing land for the Jolly Etzel claims.
And with respect to what you just testified about, is it fair to say that that category of grazing lands includes other aspects? It's not specific to grass.
Correct.
Okay. And moving forward, with respect to identifying these lands as grazing lands for purposes of conducting reclamation, did the Ericksons object to categorizing it as grazing lands?
I believe there are no objections at that time.
And let's talk about the total acreage of the Jolly Etzel claims. How many total acres were included in those 4 Jolly Etzel claims?
I believe the total permit acres is around 380 acres. I believe the proposed disturbance was around 200 acres. And so far we've disturbed about 120 acres with our mining that was occurring on this area.
Okay, and let's go ahead and open what's been marked as Exhibit BPM 85. And for purposes of this exhibit, let's go ahead and turn to page 19.
Yes. Mr. Erickson?
Yes.
This exhibit 85 is one of the ones that you objected to earlier.
Which one is it again, please?
It's exhibit 85.
85, yes. I do object to that because Jolly Etzel obviously is a separate mining from the Wyoming State lease. Jolly Etzel, basically that land did not include any trees. It did not include any wetlands. It did not include any viewscape per se. So it is really what we're comparing here is apples to oranges. The Jolly Etzel claim is completely separate from the state lease. And once again, for the Jolly Etzel, saying that we never objected to that it's only grazing land, we never saw the permit for 267C until September 2017. Once again, the 2U was fully ignorant as to what this land was classified or how it was to be mined. But now we are into a separate area that has never been mined. Jolly Etzel has seen a multitude of mining close by or on it or whatever historically. But where there is a mine on the Wyoming State lease has never been mined. It's pristine. And it does have previous uses beyond grazing lands. Okay. And to kind of also say is hunting was not occasional on this land. Hunting season and revenue from hunting has been every year.
Well, Mr. Erickson, part of your arguments kind of revolve around hunting. And if this pertains to that, you might consider. But let me look to Bentonite Performance Minerals. There are 2 questions here today, right? One of those questions has to do, does the reclamation plan restore to the highest use and in a timely manner? One could read that paragraph or that sentence in the statute continuously and look at it differently. But anyway, that's the second test. The first test is, does this operation interfere with any of the existing uses of the land? I'm going to ask you specifically, and you really have to get specific, how does this exhibit support either of those 2?
Certainly. This exhibit in the Jolly Etzel claim supports both of those.
How?
It supports them.
Yeah, I know that's your position.
Certainly. And so with respect to the first analysis of whether or not the proposed operations are going to substantially impact the existing operations on these lands. The Jolly Etzel are directly next door. We've had experience working on the 2U lands, working with them with respect to their hunting operations, given our experience on the Jolly Etzel claims, which we'll learn about. This is a continuation of the same bentonite deposit into the state lease that we intend to move forward with and continue to develop. We can take the experience that we've learned and we can inform the EQC, and we can demonstrate through the experiences of both accommodating the existing uses of the Ericksons while operating on the Jolly Etzel claims. And in addition, the reclamation methods and schedules that we implemented on the Jolly Etzel claims are identical to the reclamation methods and schedules that have been proposed for the state lands. And so what we can do is take a step back and see how we've done this in the past and how this is informing our decision moving forward. Everything from identifying existing uses, proposed future uses, reclamation schedules, and opportunities. And going even further, what our operations on the Jolly Etzels will really demonstrate is BPM's willingness to work with the service owner with respect to fences, roads, reservoirs, hunting moratoriums, all across the board. So it's very important that we understand our interactions with the Ericksons in the past and how that's informing our development of this permit moving forward.
All right, I'll allow the exhibit to be entered.
Can I rebut that?
Pardon me?
Can I do a rebuttal on that?
No, I think you'll get it. I don't think you can.
Okay.
That's my ruling. So let's let it, but I would, Mr. Yemington, so you've kind of given us a preview of what this is supposed to tell us. Take us directly to the places in this thing where we can see and read that it actually does do what you report.
Absolutely, and we'll be as straight and forward about that as possible. Mr. Tatro, you just testified that the entire acreage for the Jolly Etzel claims was approximately 380 acres. Can you identify what we're looking at here?
Yes, so we're looking at, it gives a legal description of the update lands. Update lands were lands already within our permit boundary. We just had to update some of the mining operation, as well as the IBR lands, which we had to amend into our permit, which included the road and some back sloping areas.
Okay, and I see what's been marked at 375.91 acres. Is that the total acreage of the Jolly Etzel claims?
Yes, that'd be the total acres of the Jolly Etzel claims and the road access in these claims.
And how does that compare to the total proposed disturbance?
So the total permit acres is 375. The proposed disturbance around 200 acres.
And how does that compare to the actual disturbance that was realized on the Jolly Etzel claims throughout the development?
The actual disturbance we've had is 120 acres so far in the Jolly Etzel claims.
And moving forward on that tract, how many acres per year were disturbed for the Jolly Etzel?
Yeah, on average, it was disturbed around 10 to 20 acres a year. The first year is always our largest disturbance with putting in roads and camps, and then your first pit covers your biggest surface areas. So I think we had around 40 acres our first year, and then the last year was around 5 acres of disturbance in 2017.
And what was the annual reclamation, if you know?
So the reclamation would remain current with that. So as we progress forward in our mining, we're constantly reclaiming behind us. So we'd reclaim on average 10 to 15 acres a year as well.
Okay, and with respect to acreage that's disturbed at any given time, how many acres would be sort of out of that grazing lease, for example, that wouldn't be accessible by a cow?
Yeah, so on average, you'd be around, I'd say 30 to 40 acres because after you get it reclaimed and put seed in the ground, then we have some temporary fences around there to keep cattle off there for a couple grazing seasons.
And are you required by your permit to include those temporary fences?
That's one of the conditions that we work with in our permit, as well as landowners, if it's a request with the landowners to fence out our reclamation that we abide by.
And with respect to the Jolly Etzel claims, did the landowner request that you fence out the reclaimed and reseeded acreage?
Yes, they did.
And if you didn't fence out that acreage, how much would not be accessible to a cow on any given day?
If we did not fence out the acreage, then it would just be the current open disturbed stuff, which would be around, I'd say 20 acres.
Around 20 acres. What's the current status of the Jolly Etzel claims?
Currently, it has all been reclaimed. Other than the roads, no mining operation is going on the Jolly Etzel claims.
Can we go ahead and open what's been marked as BPM Exhibit 90? Mr. Tatro, are you familiar with this photograph?
Yes, I am.
And when was this photograph taken?
I believe this photograph was taken in summer 2018.
And you please tell us what we're looking at?
90? Oh, I'm looking at a list. All right. So, Mr. Erickson, do you object enough to Exhibit 90?
I do, but once again, I can't access these online. When you guys go to open up the exhibits on your site, only some of them are viewable, and a lot of them are disabled. So I don't know what photograph BPM 90 is, but I can make the comment that if it doesn't include trees and wetlands, then it's not relevant to the restoration of the Wyoming state lease. All it is previous use of grazing, which is not relevant to the mining that will occur.
Okay, Mr. Erickson, thank you. Now, I got to look to our staff. Staff, this exhibit's disabled. Now, what is your procedure? If I accept the exhibit, do you then enable it so that Mr. Erickson can see it?
We do. Mr. Erickson also has two other options. I believe that the exhibits were provided in either a paper form or a digital form by BPM. And if he logs into the system as the party, he can access those without us enabling. He has a password and username.
Okay, which I do not, to my knowledge.
It may have been sent to wrong. We can.
All right. So, Mr. Erickson, are you into the Environmental Quality Council docket?
Yes, I am. And if you look at the exhibits, some of them are enabled.
Yeah,
okay?
Correct. But some are just...
1 and 2, and then BPM 1 through 4 is enabled. Let me scroll down here.
Yeah, but let me just take you, in the interest of time, scroll down to BPM Exhibit 90.
90,
okay, which is the one that we have before us today. Now that's disabled. Now
disabled.
Okay, I'm going to overrule your objection and allow them to tell us what they want to do with this particular exhibit.
Okay.
So if you could enable Exhibit 90.
Yes.
Certainly, and just quickly to provide foundation with respect to how this is relevant to this proceeding.
Well, this one, see, I thought we're going to go back and we're going to. Okay, go ahead.
Certainly, and just to provide some foundation quickly, we're trying to get through this as quickly and straightforwardly as we can. What we believe this demonstrates is again, we're talking about contiguous adjacent lands that BPM has operated and implemented the same schedules and methods that they propose for the state lease lands. These lands were reclaimed completely in 2017, and this photograph was taken the following year. What this demonstrates is that not only can BPM reclaim, but they can reclaim well. And so I'd like to have Mr. Tatro provide just a little bit more conversation about what we're looking at and what went on.
Okay. Go ahead.
So are you familiar with this photograph?
Yes, I am.
And again, when was it taken?
2018.
And what are we looking at?
So this is a reservoir that we constructed on the Jolly Etzel 15 claim. This is per the request of the Ericksons. They wanted us to construct a reservoir. We were able to incorporate that into our mining sequence. We were able to put it in, actually this one was towards the end of a pit sequence, so it worked out well to put this in here, but we created a pond, put it in the reclamation plan, revised it to incorporate these ponds, as well as permitting it with the state engineer's office.
And why did they want a pond?
They wanted this pond because they wanted to increase the water capabilities on their property.
For what purpose?
I believe the purpose would be for grazing and wildlife uses.
Okay, and Michelle, I'll just ask you to slowly scroll through the next 4 slides. I believe these are also just photographs of the same pond, but Tyler, please quickly, if there's something you want to add.
No, this is the subgrade pond that we created. I believe it's about 15 to 16 acre feet. It's a depth of about 12 to 15 feet. It's only had about a year and 1.5 growing seasons for the grass on there. See a lot of sweet clover that came in this year. We had a big year for sweet clover that year.
Any comments with respect to this picture?
No, just another picture of the area that was reclaimed.
Okay. All right, let's move forward.
It's not on the 2U, it's on Sextus. Not on the 2U ranch.
This one?
There's a door on a separate ranch.
Yeah.
Tyler, just for clarification there, was this reclamation of the Jolly Etzel claims?
Yes, this was of the Jolly Etzel claims.
And when you permitted those Jolly Etzel claims and agreed to a surface use agreement with the Ericksons, that was with Lonesome Country Limited that covered all these lands?
Correct.
And now those lands have been split up into multiple entities?
Correct.
And to your knowledge, how many entities now cover the good Jolly Etzel claims?
To the Jolly Etzel claims, I believe there's about 4.
Okay. And if you add Glam on the Hall Road, would that be 5?
Correct.
Okay. And did you receive any objections from the surface owners, whoever they might be at the time, that the reclamation wasn't taking hold, or that they had objections or weren't seeing what they wanted to see with respect to reclamation on the Jolly Etzel claims?
No, I don't believe there's any objections to it, just the request to add ponds during our mining process.
And did you receive any notices of violation from the Wyoming DEQ with respect to your reclamation operations on the Jolly Etzel claims?
We did not.
With respect to the existing operations that you identified earlier in your testimony, do you believe that BPM accommodated those operations?
Yes, I believe we did.
And do you believe BPM substantially prohibited any existing operation from occurring?
I don't believe so. We accommodated the grazing with the cattle, and then also their hunting needs. We volunteered to move our mining equipment out of there during the deer hunting season.
Let's take that step by step. With respect to grazing, what did BPM do to accommodate that operation?
We put in grasses that were reviewed by the surface owners, as well as constructing reservoirs per their requests, and then providing fences as needed per their request.
Okay, and how many reservoirs did they request on the Jolly Etzel claims?
We were able to put in, per the request, two reservoirs at this time.
And are you required by statute or regulation to build or install or rebuild or fix reservoirs?
If there's not a reservoir there, we're not required to build a reservoir.
You mentioned fencing.
Correct.
And what was the purpose of the fencing?
The fencing was to keep the cattle off the reclamation. We also had the Muleshoe Ranch. They're the ones who performed the fencing because they run the cattle on there, so they best know how to put the fences on place to accommodate their grazing needs as well.
What about roads?
Also, we constructed roads that could be used for our mining operation, for the hunting operation, and any needs for the grazing or Ericksons as well.
And during the process of developing these operations and implementing these operations, did you include the surface owner?
Yes, we did.
Is it fair to assume that this existing permit, the reclamation plan that you have developed for the DEQ to review, does it have all of this in that plan?
The one that for state lease 04?
Well,
we can walk through that quickly.
Well, let me come back. You know, we're trying to determine two things, right?
Mm-hmm.
Okay, one is, does the proposed operation prohibit existing uses? And the second, does the reclamation plan restore to the present?
Certainly.
In a timely manner. Okay. This exhibit shows lands where? In the proposed permit or in a prior permit?
Their lands in the 267C permit, and so our state leases were mending lands into the same permit, so same reclamation
But
practice.
this new action is an amendment to that permit.
Correct. And so for clarification,
So in the new action, you have written in that reclamation plan for the amendment, this sort of thing that you're saying you've done before.
We do.
yes, and Tyler, is it your testimony that the reclamation, and I know we'll get into this in more detail with Jen Hartman, but is it your testimony that the reclamation plans and schedules for the Jolly Etzel claim are identical to the plans that have been proposed for the state lease?
Yes, they are.
With respect to hunting, did you accommodate the hunting interests of the Ericksons for the Jolly Etzel claims?
Yes, we did. They requested that we stop our mining operations at, like, again, usually during the deer rifle season for the month of November. That was not a requirement in our permit, or was not a requirement in our.
Is the requirement in the permit the amendment?
I think what our response would be is that you'll hear testimony that BPM has agreed to accommodate the hunting operations for the state lands in the exact same manner that they accommodated them for the Jolly Etzel claims.
We would do the same thing.
With the point being is that we didn't substantially prohibit the hunting operations for the Jolly Etzel claims, and we intend to use the same approach for the state lands. Moving forward, did you apply dust suppression on any of the roads or do anything else to limit nuisances?
Yeah, during our hauling operations, we water the roads for dust suppression.
All right, let's move forward to the state lease lands, please.
Okay.
Michelle, again, let's, if we can, just revisit what's been marked as BPM exhibit. Let's try 130.
Okay, now stop before you show that to us. So like, the 130 is not one of the ones that, okay, go ahead, see.
So do you have anything?
Yeah, 130 is
Let's try 105 again. It's just the map that we looked at the beginning for purposes of figuring out where we're at. Okay, and Joe, if we could turn down the lights just quickly, just to have Tyler remind us where we're at in the world. Tyler, can you identify the state land permit boundary?
Yes, you can. So state land permit boundary, it's this yellow and red boundary right here.
Okay, and then again, you just were discussing or providing testimony on the Jolly Etzel claims. Can you generally identify where those claims were?
Yep, they're immediately adjacent right here in these carved out areas, and then right over here.
Mr. Hearing Officer?
Yes.
Could I ask the witness to identify by number? I see numbers on this. That'd be helpful, I think, for me and perhaps for others.
Sure.
Like I see a number 31 kind of in the middle of a, you know, and I see a 32 and stuff like that.
Yeah. So the state lease for permit boundary is in majority of section 31. A little bit goes up into, I believe it's section 30 to the north. And then the Jolly Etzel claims as well. They're down section 6, 5, and then a little bit in section 31 as well.
And Tyler, would you agree that those Jolly Etzel claims were directly contiguous to the state lands?
Yes, they are.
And would you agree that the bentonite deposits under the state lands are a continuation of the bentonite deposits that BPM mined for the Jolly Etzel claims?
Yes, it is. It's a continuation deposit, and that's why our proposed plan was going to be mine the Jolly Etzels and just to keep advancing on that same deposit into state lease 04.
Okay. And remind us who the mineral ownership of the state lease is.
The state lease is the state of Wyoming.
And how does BPM have a right to mine these minerals?
We have a bentonite strip mining lease with the state of Wyoming.
And does Bentonite Performance Minerals compensate the state of Wyoming for the right to mine their minerals?
Yes, they do. They receive royalties based upon the amount of tons that we mine.
Any idea how many based on current prices?
Based on current prices, this would be around $3.5 million.
And does that include taxes?
That does not.
And who owns the surface of this?
The surface of this is mainly owned by the Ericksons, mainly the 2U Ranch.
Are there other surface owners now that you're aware of?
I believe there are 2 more new surface owners, which would be the Cinquefoil and the Valkyrie surface owners on the outer edges of the permit boundary.
And is it your understanding that those are owned by the Ericksons?
Yes, it is, my understanding.
And what is your understanding of the existing operations on the surface lands?
So the existing operations on the surface lands for this area is cattle grazing as well. Hunting occurs there. The bentonite mining with American colloid hauling right through this permit boundary. And I don't believe there was any logging activities that taken on in this place.
Okay. And for purposes of comparing this to Jolly Etzel, you testified that Jolly Etzel encompassed 375 acres. What about the state lease?
The state lease is 600 acres. Of that, we have a proposed disturbance of 177 acres.
177. How does 177 compare to the Jolly Etzel claims?
So this would be a slightly less disturbance than on the Jolly Etzel claims.
And again, is that a maximum disturbance?
Yes, the 177 acres is a maximum disturbance that we have. That's what we propose. If we're going to go anything larger than that, we have to revise our plan. Typically, the actual disturbance is less than the proposed disturbance.
And why is it typical that the actual disturbance is less than the proposed disturbance?
We base the proposed disturbance on We drill the property, we figure out the depth of the ore body, then we offset a buffer depending on type of slopes that we're going to mine. We typically use a 3-to-1 as a conservative number, but a lot of the side slopes that we'll use on this would be closer to a 1-to-1. So the actual disturbance will be less than the 177 acres proposed, but we like to use the number that most likely reflects what our most disturbance would be for the operation.
Okay, and did you ever communicate this to the Ericksons with respect to how you calculate this disturbance and what the actual disturbance might be?
Yeah, we sent them the proposed disturbance in the permitting process.
Okay. And remind us, with respect to the Jolly Etzel claims, you proposed 200 acres of maximum disturbance. What was the final number?
Right now it's 120 acres.
And for purposes of the state lease, what do you anticipate the disturbance per year to be?
I believe it'd be on the same type of schedule as the Jolly Etzel, so we would anticipate anywhere from 10 to 20 acres on an annual basis disturbance.
And what would your expectation be with respect to average acres reclaimed per year?
The same thing would be with reclamation. We would reclaim it as we advance with our mining. And
why would you say it would be the same as Jolly Etzel?
Because we're adopting the same mining practices, advancing the same ore body. It's the most efficient mining and reclamation method that we have. You're handling the material less, but at the same time, it's the fastest way that we can reclaim the area.
Okay. Let's go ahead and look what's been marked as BPM Exhibit 5.
Exhibit 5. Mr. Erickson, this is one that was on your list previously, is that correct?
Yes, it is.
And your objection,
And the reason
yeah.
my objection is because this was dated or occurred prior to September 2017. That is the date in which we received materials from BPM that basically illustrated what damages the mining would do. We received the vegetative, wildlife, and wetlands plan. Prior to this point, we had no clue what the mining was going to entail other than the reclamation plan that was incomplete and the mine plan that was incomplete. So this, to me, anything prior to September 2017 is irrelevant because we were negotiating basically blindly.
Mr. Yemington, what is this? What do you intend to tell us about this exhibit?
Certainly, BPM approached the surface owner beginning in 2015 to amend the mine permit to include the state of Wyoming permit lands. In doing so, they engaged with the surface owner to better understand what those existing uses were, and they amended the mine and the reclamation plan to reflect those existing uses and accommodations that were requested by the surface owner. It's highly relevant to the analysis of whether or not we identify the exhibit. Mr. Tatro, do you recognize this exhibit?
I do.
And what is it?
This is a proposal to amend the current surface use and haulage agreement that we had in place with the Ericksons.
And remind me what that surface use and haulage agreement was for at the time?
So the current, or the surface use and haulage agreement at the time was for access to the Jolly Etzel claims. And then we were going to amend additional lands that incorporated the state lease 04.
And I see a date that appears to be written in the top right-hand corner of January of 2015. Any reason to believe that date is not accurate?
I believe that date's fairly accurate because the proposed date on this is February 1st, so it would have been submitted prior to that.
Okay. And prior to this date, just very briefly, had you engaged the Ericksons or anyone at BPM, had they engaged the Ericksons with respect to your desire to amend the permit to include these additional lands?
Yes, there were Jennifer Hartman and the mine manager actually met with Ericksons at their place in the summer of 2014 to discuss, the process of amending the lands, collecting baseline data, that we're going to be amending that state lease 04 into our permit to mine.
Okay. And did the Ericksons respond to your request to amend the surface use agreement?
Yes, they did.
Would please direct your attention to what's been marked as BPM 06.
Once again, I object. Because these are negotiations based off of not knowing until September 2017 what they plan to do for mining. So we once again were clueless, ignorant, in the dark as to negotiating with these guys because we did not have the data. They did not supply it until September 2017. And after that point, you will realize negotiations radically changed because now we understood these guys were going to wipe out 7,000 trees, wetlands, viewscapes, so forth. So this is not relevant. These were not negotiations done in good faith because we did not know. We were clueless. We were kept in the dark.
Okay, I'm gonna go ahead and read this again, and that the use does not substantially prohibit the operation of the surface water. That use has to be described somewhere in a permit amendment application. Is that correct?
Correct.
And the other one is proposed plan reclaims the surface to its approved future use in segments if circumstances permit as soon as feasibly possible. I am going to agree with Mr. Erickson on his objection and I'd like to remove that Exhibit 6.
Could I make one comment? There's one specific sentence in this email from Mr. Erickson that identifies the existing operations as of 2015. It's highly relevant to how BPM developed the mine plan and the rec plan. He identifies 3 specific operations that he has concerns will be impacted by bentonite mining and the proposals for the state lease. He identifies them in this letter, and it's highly relevant because based on this letter, BPM took steps to accommodate their logging operations, their grazing operations, and their hunting operations. He has never alleged that they were.
Okay, I'll back off, but you know, Mr. Yemington, Mr. Erickson does make some points about where and when some of this correspondence took place.
And I'd like to.
Again, I want to remind you that I'll accept it this time, but kind of thinking that our review is more limited to what you have proposing to do for a reclamation. Not so much that how you got there. Okay.
Understood. With the one comment that I do think it's important to.
Mr. Erickson, I'm taking back. I'll allow this exhibit to be entered based upon Mr. Yemington's statement that he believes it's relevant. So go ahead and explain to us why that is.
Mr. Tatro, are you familiar with this document?
Yes, I am.
And what is it?
This is Scott's response to the proposed surface use amendment.
And can you read the first sentence of the 3rd paragraph, please?
We understand the need for mining, but we are also aware of the potential negative effects on livestock hunting and logging operations.
And based on your understanding of those lands, did this align with your understanding of the existing uses that could be impacted by the proposed mining?
Yes, it is. At the time, we were aware of the livestock and the hunting. The logging was new to us, but it was a use that they're looking to use.
And did the Ericksons or did Scott Erickson identify any requests beyond this with respect to accommodating these operations?
Yes, he did.
And where did he identify those?
They're down below in the email.
Okay, let's take a look at those bullet points and very quickly. What was the first bullet point?
That was just a proposed different haulage rate.
Okay, I don't think that's relevant to this proceeding. What's the second bullet point?
Additional fencing road development for their livestock lease with Muleshoe Ranch.
Fencing and roads?
Yep.
What's the third bullet point?
The third bullet point would be the development of reservoirs.
And the fourth?
Stop mining operations during the deer hunting season.
Fifth?
And then have the marketable ponderosa pine trees accessed by a third party.
And the last?
Is to review the grass seed for grass seed production.
Okay, and did you respond to this letter?
Yes, I did.
And did you respond to those bullet points?
Yes, I did.
And what were your responses? Let's go ahead, and if it's allowed by the hearing examiner, BPM Exhibit 07 would include your responses. And again, we'll limit this to those 6 bullet points.
Once again, I object because we are getting outside the scope of item C and D. Also, once again, these were negotiations done blindly, not in good faith, because once again, 2U had no clue until September 2017 what mining was going to occur and what would be the devastating effects.
Okay. The objections overruled. Go ahead.
Go ahead, Mr. Tatro. Skipping again the first bullet point, which is not relevant. How did you respond to the second bullet point with respect to his request for roads and fences to accommodate his grazing operation?
Yes, I said we can work with Caleb Descartes Mule Shoe Ranch to perform the fencing on this area as well, like we did in the past.
And what was your response to the second bullet point?
That we could construct reservoirs for this area as well, as long with get the approval of DEQ.
And what was your understanding of what those reservoirs were for?
Would be livestock grazing.
And what was your response to the third bullet point?
That yes, we could stop mining operations during the deer rifle season.
And did this align with what you had done on the Jolly Etzel claims?
Yes, it did.
What was your response to the next bullet point?
That yes, we could work with a third-party timber contractor for the marketable timber.
And again, the last bullet point?
That we can work with them on the seed mix and adjust our seed mix as approved by DEQ.
What was your understanding of the hunting, or excuse me, the logging operations on the Erickson lands in January of 2015?
My understanding, it was not occurring, but it was something they're looking to do in the near future.
Very good. And did you move forward after this with the permitting application?
Yes, we did.
And how did you move forward?
So we moved forward with, this time we're collecting the baseline data still, putting it all together from our contractors, so that way we can start developing a mine and reclamation plan.
And did you continue to engage with the surface owner and work with them as part of that process?
Yes, we did. We actually met in July of 2015 as well at their ranch facility to discuss some of the activities for this permit amendment boundary.
Okay, and I think that raises a point here. You said you met in person in July of 2015.
Yep.
Did you usually meet in person? We've looked at a few correspondences, emails, letters. How do you usually interact with the Ericksons and why?
Most of the interaction with them occurs in email because they're located in Texas. So we try to accommodate with meeting in person in July. That's typically when Scott is in the area, as well as Ronald Erickson.
Why is it typical that Scott's in the area in
You're gonna
July?
have to slow down, please.
I'm sorry.
Same thing.
Why is it typical that Scott is in the area in July?
I believe he lives in Texas and is a professor down there, so he comes up during the summertime.
And approximately how much time does he spend on the ranch?
I know that he's typically around there in the July timeframe. I'm not sure when he leaves to head back to Texas.
Okay, and we've talked a little bit about existing operations, but again, to your knowledge, does Scott hunt?
Not to my knowledge.
To your knowledge, does Scott own cattle?
Not to my knowledge.
How'd the meeting go in July of 15?
It was good. It was a meeting that we highlighted some of these issues and proceeded with our plans to permit this area.
What was discussed at the meeting, if you recall?
As I recall, we discussed the grazing, putting the fences in. We discussed working with the timber contractor to show our disturbance areas, as well as putting in reservoirs as much as we could.
With respect to the timber contractor, did they request anything from you?
Yeah, they wanted a kind of a proposed disturbance area so they could look at it to see if there's any marketable timber.
And did you provide a shape file to the timber contractor?
Yes, I did.
I'm sorry. You're gonna have to slow down.
I'm sorry.
Can you repeat it?
Yes. Tyler, did you provide a shape file to the timber contractor as a result of that meeting?
Yes, I did. I provided a shape file of our proposed disturbance boundary to Bill Coburn, the timber contractor.
And what was your understanding of how the timber contractor would use that shape file?
To determine if there's any ponderosa pines that they could log on the property.
And to your knowledge, did the Ericksons enter into a timber sale agreement with the timber contractor?
Yes, I believe they did the following year in 2016.
And to your knowledge, were portions of the Ericksons ranch and to you logged?
Yes, I believe that they started logging on the Ericksons property.
And was it the intent to log the state lands prior to BPM conducting mining operations?
Yes, that's one of the things that we discussed in the meeting, was to have the timber company come in and log the pine trees prior to us going in there and disturbing it with our mining operations.
And did you agree to work with the timber contractor to the extent you needed to accommodate that?
Yes, we did.
Can we go ahead and open up what's been marked as BPM Exhibit 18?
Excuse me.
Could you say that again, please?
Mr. Erickson, before he gets to the next exhibit, Chair Lally has a question. Go ahead.
Okay, Mr. Emmington, you keep referring to the state land. Is that land owned by the state, or is the land owned by 2U and the minerals?
Yeah.
I want to be clear.
Apologies.
I'm
for
sorry, I did
confusion.
not hear that.
I asked if the lands that he's referring to as state lands are owned by 2U or are just the minerals owned by 2U, just for my own clarification.
Certainly, and so sometimes apologies, I've maybe referred to the subject lands or the permit amendment lands or the state lands. What I'm referring to is Wyoming State Lease 42804, which covers the bentonite minerals and only the bentonite minerals underneath those lands that are owned, the surface estate, by 2U Ranch.
Okay, I just wanted to be very clear.
Yeah, certainly, and I'll do my best to be clear about that as well, because it is an important distinction.
Okay, Mr. Yampton, what's your next?
We would like to bring up what's been marked as BPM Exhibit 18, if it's allowed by the hearing examiner.
Okay, and,
Once again, I'd like to object.
yeah, and go ahead, Mr. X, sorry.
We'd like to object because all the logging was basic negotiations was, once again, prior to us finding out in September 2017 that they were going to knock down entire forests. We were under the impression, when we negotiated on the logging, that they were only going to remove a handful of trees. And they were not, we didn't realize they were going to clear cut 11,000 trees. Once we realized that, negotiations changed and we said no. We did not want logging to occur. We do not want clear cut forests. So all of this basic negotiations prior to September 2017 is outside the realm of the 2 points of this hearing. That's C and D. It's irrelevant. We're going off on a rabbit trail smokescreen.
Can I respond to that quickly?
You may.
And for purposes of this response, I think it would be valuable to direct the council to what's been marked as BPM Exhibit 17. There's a reason that Scott Erickson does not want to talk about these exhibits, because it undermines his case. BPM Exhibit 17 demonstrates irrefutably that the Ericksons wanted 100%, their words, of the trees removed. Now, let me be clear. BPM doesn't agree with the Erickson statement with respect to how many trees will be removed by the proposed mining operations. And BPM definitely doesn't agree that that's relevant for purposes of this.
Now,
but to the extent we're hearing this from Mr. Erickson today, it's only fair that we have the opportunity to demonstrate that they have completely changed course, that we filed a mine and a reclamation plan based on good faith efforts to accommodate their operations. And to the extent they no longer want those because they couldn't reach an agreement for compensation with BPM, they cannot be allowed to ignore what they said in 2015, 2016, and 2017. They told BPM they wanted 100% of those logged for purposes of establishing grazing land because trees were weeds.
Mr. Hamilton, on the topic of logging, how many more exhibits will we be, are you going to propose to present? We go through the subjection process. You just stated your case.
We have 2 exhibits that we'd like to show you now. We weren't going to bring them up, but based on his comment there, I think is highly relevant and important for purposes of setting the record straight.
Well,
Mr. Hearing Officer, I'm probably out of line, but I just want to ask here. I think we have heard what the use has been, and what and that gets at number C. I mean, I've heard there's logging, there's hunting, there's grazing. If that's what we're, and you know, I know what those are. I think most council members know what those are. Are there other uses that are a concern? And these negotiations that go back into the past are always, I know these kinds of things are always out there. But I know what the uses are. And then, so now my question is, okay, get the number D, but that's just me. But I think I know what the uses are unless there's another use.
Well, I would volunteer something at this point. I agree. I think a lot of this noise on the periphery is not relevant for purposes of this proceeding. We're trying our best to keep this between the lanes. To the extent they raise issues that we need to respond to, I think it's only fair that we have the opportunity. Now, I would volunteer that perhaps we could withhold our opportunity to respond to those until Scott, we anticipate, brings those up in his case. But I would ask that these exhibits that we're holding back, that we be allowed to bring them up in the event Scott wants to make that case during his direct.
Yeah.
Maybe I'm confused, maybe I missed something, but the real question here to me is whether or not we see these exhibits know is, does the mining affect future logging? That's really the question, right? So, sure, it's future. Well, does it infringe on the ability to log that property? So to me, those exhibits may be just a little bit necessary to decide what those plans were in the first place. I mean, if they'd already agreed to log it, and obviously mining does not infringe on the ability to harvest that timber. On the other hand, if we're talking about the mine going in there and ruining those trees, prohibiting them from ever being harvested, that's a different argument. So to me, we need to get to a choice about where that timeline is and who decided what, and if those choices were able to be made or not. And that's why I think it's relevant.
Okay. Well, as you can tell, the council is, let me first of all, I'll overrule the objection. But I will, I think Mr. Yemikin, you talked about trying to consolidate some of your stuff, reserve it for later.
Yes.
That would be good. You don't bring that up, and we'll go through this objection process repeatedly. You now have a pretty good sense of where the council is on this matter. And so go ahead and I'll allow that I'll overrule that objection. But again, be brief.
Absolutely. And we will reserve that in the event it comes up. Well, we'll deal with it at that point. So Tyler, ignoring those exhibits with respect to what we were just talking about, the third element of this analysis contemplates whether the operations as proposed will substantially prohibit the operations of the surface owner. Do you believe that, as proposed, the mine permit application will substantially prohibit logging operations on the state lands if and when 2U decides to move forward with the logging operations that they communicated a desire to do so?
No, I don't believe it's prohibited because the plan with them all along was to have it logged prior to us even mining that area.
And to the extent possible, did you attempt to accommodate their request with respect to providing those shape files and interacting with their timber sale contractor?
Yes, I did, and it sounded like in the beginning of 2016, they reached agreement with the timber company, and so they're going to begin logging it very shortly in February, which was still prior to us planning on mining this area.
Thank you. Tyler, do you recall anything going on in January of 2016?
In January 2016, that's when we first provided a mine and reclamation plan to the Ericksons.
And did the mine and reclamation plans incorporate the request that Scott Erickson had made in January of 2015?
Yes, it did. We took those requests, did what we could to modify our mine and reclamation plan when we provided it to them in January of 2016.
And which requests, or how did it accommodate them? I mean, how did you really do that with respect to the permitting process and then developing the mine plan and the reclamation plan?
So initially it was a proposal to develop any reservoirs as requested, work with them on doing any fencing as needed, obviously logging prior to, and then if we had areas to put reservoirs in their mining sequence, we could accommodate those needs, as well as reclaim the slopes to an area that they could want to, if they wanted to combine the reclamation seed, they could do that.
And why would they want to combine the reclamation seed?
In the past, they've done that on American Colloid. They'll go in and combine it so they can harvest the seed and sell it.
And who do they sell it to?
I believe at that time they sold it back to American Colloid.
And would they presumably sell it to Bentonite Performance Minerals for their reclamation?
That was one of the things that they were proposing.
Okay. I'd like to direct your attention to what's been marked as BPM Exhibit 24. And briefly, Tyler, do you recognize this?
Yes, this is Scott's email.
Once again, I object.
Yeah, right.
Because
There's another
again,
objection.
this is prior to when we received information on how they were going to mine. Negotiations were not conducted in good faith. Once again, 2U Ranch was in the dark and ignorant as to what mining destruction was going to occur. This is all irrelevant.
We can move forward without the exhibit.
Very good. Please do.
Tyler, you just testified that.
Mr. Erickson, they're moving forward without the exhibit, so I'm not making a ruling on your objection.
Okay.
Just to be clear.
Mr. Tatro, the mine and reclamation plans, well, let's start with the mine plan. The mine plan submitted to the Ericksons in January of 2016, did that identify the proposed surface use and surface disturbance?
In the mine plans, yes, I believe they did, because we presented them with the mine plan maps and reclamation maps at the time.
And would the mine plan map identify the proposed disturbance of the surface lands?
Yeah, we put the mine plan maps on an aerial imagery because it'll show where our disturbance is so you can determine where it will be located on the property.
Okay. And I would direct the attention of the council to what's been marked as BPM Exhibit 2.
Exhibit, pardon?
2, please. Mr. Tatro, do you recognize that exhibit?
Yes, this is the most recent mine plan for the state lease permit amendment.
And was this mine plan addended to the mine permit application submitted?
Yes.
Department of Environmental Quality?
Yes, it was.
And is it comparable to the mine plan map that was submitted to the Ericksons on January 8th of 2016?
Yes, it is comparable to that map.
And how is it comparable?
Because it identifies the disturbance boundaries, the pit crust, the mining sequences, and the proposed roads.
And again, Joe, if you don't mind, can we turn down the lights just a bit? And Tyler, with your laser pointer, maybe just identify what you just testified to. To the extent you need to stand up, I think we can move the microphone just a little bit.
Yeah, so it's a little bit tough to see, but the purple line is the proposed disturbance boundary. It kind of runs around this way. The mining would start in this area, as we say, continuation from the Jolietza claims. We'd mine in this sequence and come around this way. These are the proposed roads that we were going to use for our roads within this area.
And Tyler, I think I see what maybe is a fourth pit in the corner. Is that correct?
Could you? Oh, yes. There's just a small little area right over here.
And how many pits did BPM propose in January 2016 to mine?
But there were different pit sequences. There were about 4 different pit sequences that were series that we were going to do.
Okay. And earlier you testified with respect to the proposed total acreage of the permit, and then within that, the total proposed disturbance acreage. Is that identified in this?
Yeah. So this would be the 600 acre amendment boundary. Then this would be the 177 acres that corresponds with the mining reclamation.
And again, is that the maximum disturbance?
That is correct.
And is it likely that it'll be less than that?
Yes, it is.
And as marked on this map, would the Ericksons have known what that proposed disturbance was in 2016?
Yes, I believe it'd be identified when this was presented in 2016 because it shows our proposed disturbance boundary over aerial imagery.
And would have been the identical lines on the identical map?
Yes, it would.
And you mentioned that, and I don't want to confuse that word identical, but you mentioned there had been some changes. What changes between the January map that was submitted to the Ericksons in 2016 to the final map that was submitted to DEQ for purposes of processing the permit?
For the mine plan map?
Were there any changes in the mine plan map?
The only changes was the additional road on the very east side of the permit. Other than that, I believe most of the stuff in the mine plan map remained very similar that was in 2016.
And did the Ericksons request any changes with respect to the mine plan map or the disturbance or how you identified that disturbance?
The only changes or requests that they had was for additional roads.
Additional roads?
Correct.
And would that have shown up on the mine plan map?
No, some of those roads were located going outside of the permit boundary.
And did BPM agree to build those roads?
Yes, that was one of the things we agreed to do, but it wasn't in conjunction with the permit application.
Okay. And because it's not in conjunction with the permit application, even if you agree to build them, would they show up in the permit application?
They would not. That was one of the things we spoke with our permit coordinator, and he said that was more contractual work. It wasn't something they were concerned with.
And what was your understanding, the reason that 2U or the Ericksons wanted these additional roads?
They wanted those roads for just access of their property for any hunting or livestock needs or just to get around the property.
And are you required by your permit or the Environmental Quality Act to build roads outside the permit for the surface owner?
No, we are not.
Did the surface owner make any other requests with respect to either the mine plan or the reclamation plan?
Yes, there were additional requests.
Let's go ahead and take a look what's been marked as BPM Exhibit 3. Excuse me, let's go to 4. Mr. Tatro, do you recognize this exhibit?
Yes, this appears to be, excuse me, the reclamation plan.
I'm sorry.
Excuse me, the reclamation map.
Okay, and would this be similar or identical to the reclamation map that you submitted to the Ericksons in January of 2016?
I believe this one has the revised changes they requested with constructing some more reservoirs.
And let's walk through those. What requests did you receive from the Ericksons and from whom?
So those requests were one of the things we mined through a reservoir to make it better, and then put in any additional reservoirs that we've seen fit.
Okay, well, let's stop there. You mentioned mining through a reservoir. Can you identify that reservoir on the map?
Yeah, so with our proposal, we were going to mine through one reservoir. Excuse me. We've been located right down in this area right here.
In the bottom of that draw.
It's where the one is located right now. It's kind of on a, I guess, open area. It's not quite in the draw, just in a little open area.
And it was your proposal to mine through that reservoir, and what was their request?
It was our proposal to mine through it, and the request was to put a reservoir back, in better condition.
In better condition. And I think we'll get into that in a few minutes, but you mentioned some other requests with respect to additional reservoirs.
Yes, the other one would be construct additional one right over here. The other thing that we were going to do is we made this road coming through here. Our plan was to divert water to run into this reservoir, into this reservoir to capture as much runoff as possible, to make sure we're constructing reservoirs that are going to fill with water and not just leaving holes in the ground.
And those were requests from the surface owner?
Correct.
Any obligation in your permit or your permit amendment application or Environmental Quality Act to build reservoirs for the surface owner?
No, we just we do it per the request of the surface owner.
And that's similar to the request we received for the Jolly Etzel claims?
Correct. Additional requests, we're just going to be cleaning out some of these other ones that were located outside of our mining disturbance boundary, but they wouldn't be impacted by a mining operation.
Okay, and just for clarification, outside the boundary means that they would not be impacted by disturbance?
Correct.
Okay. Any other requests from the surface owner?
The other requests were just fences, putting fences online.
Okay, and did you incorporate? I mean, it appears you incorporated their requests into the both the mine plan or more specifically the reclamation map, the reclamation plan.
Correct.
And did you feel that you had incorporated all the requests?
Yeah, at that time it felt like that we incorporated all the requests.
And in your best estimate, what was the purpose of the fencing?
My best estimate was they're used as reclamation fences, but there are some fences that weren't located on the property lines. They wanted to move back on the property lines.
Okay, and the roads that they requested, what was your understanding of their use of those roads?
Just to access different parts of their property more easily.
And were those roads necessary for the development of the bentonite minerals under the state lease?
No, some of those roads would not be. Our plan was we were going to reclaim the roads we reclaimed or remade to their desire. If they wanted it pushed back to a 2-track or something, a pickup get down, we'd reclaim it to that nature. But anything else would not be pertaining to our mining operation.
And with respect to the reservoirs, what was your understanding of the use of the reservoirs?
The use of the reservoirs would be request made for the livestock utilization, so we want to increase the capacity.
And I think we can turn the lights back up.
Just to maybe it was pretty much assumed by me that if you built a reservoir, it'd be used for livestock. Just kind of compress the amount of time we have.
If that's something that's understood by the EPC,
I don't think that this council needs to think. We don't need to know about.
That's fine. I think what we're just trying to demonstrate is how we've
So
accommodated.
looking at the time, it's 10 to 11. And incidentally, this council is going to need to take a break. And, sometime during the noon hour for a while, we've some of us have been asked, some of the members of the council have been asked to go visit with legislators. So that's time. We can come back in the afternoon and go for a long time.
Well, my expectation with respect to this witness is
This-
approximately 20 more minutes. If that's
Okay,
amenable to
very
the
good.
council.
I'll proceed as please at a brisk pace.
No, so brisk.
Getting pressure from both sides.
Speak slowly and make an assumption that the council has enough background to know what a pond would be used for and that sort of thing. Like to say a little bit.
Sure. And
Using that only as an example.
Tyler, moving forward, were there any requests from the surface owner that BPM was not able to accommodate?
Yes, there were some additional requests later on that we could not accommodate.
And what were those requests?
There were requests that wouldn't pertain to the mining as far as putting in different types of fences, building reservoirs on different parts of the property, putting water lines in, and all sorts of different things.
Did they request a bridge over the Bellfish River?
That was an additional request that they made, is for us to put a bridge over the Bellfish River to, they can access different parts of the property.
And did that have any bearing on the mining operation proposed by BPM?
No, it did not.
And you mentioned an underground stock watering system. Can you describe that briefly?
Yeah, it was a request to drill a well next to some power that was nearby and then bury a bunch of water lines and put in about 2.5 miles of pipe with tanks spread throughout it.
And roads connecting those tanks?
Correct.
Did you follow up with BPM, with your boss, to find out whether or not that's something you could possibly do?
Yeah, that's something it's a request that we don't typically see. It's above our normal surface use agreements, so it was one that we had to speak with the people in our corporate offices.
And did they decline to build the bridge?
Yes, they did. They declined to build the bridge.
Decline to build the water,
Yes,
underground water system and the water well?
yes, they did.
With respect to the request that BPM agreed to accept and to adopt, you adopted those into the mine permit materials, specifically the reclamation plan, is that correct?
Correct.
And then did you submit those to DEQ for processing?
Yeah, it was submitted to DEQ in February of 2016.
And what's the status of the permit application?
The permit has not been processed. It's still pending.
And why hasn't been processed?
The permit has not been processed.
Question. So the DEQ is not determined completeness either?
Well, it wouldn't be determined complete because it's missing the surface owner consent form.
Thank you.
Answered my next question. Thank you. Quickly, Tyler, again, element C of the order in lieu of consent analysis requires that BPM design these operations and the surface use not to substantially prohibit the existing operations of the surface owner. Do you believe that as designed, the proposed mining and reclamation on the state leased lands will substantially impact or prohibit the grazing operation?
I do not.
Do you think it will substantially impact the hunting operation?
I do not.
Do you think it will substantially impact the logging operation?
I do not.
Moving forward, I'd like to direct your attention in what's been marked as 2U Exhibit 2. Mr. Tatro, are you familiar with this document?
Yes, I am.
And what is this document?
This is to use reasons why the concerns about with our mining operation.
And when were you made aware of this document?
Just recently.
And have you had an opportunity to review it?
I have.
So if we go through this quickly, you'll be able to provide testimony that supported by your previous review and understanding of this document.
I will.
Let's take a look at the top. It appears that they have some concerns with respect to grazing. If you look at the first paragraph, they allege that the proposed mining will cause a substantial loss of grazing revenue over the course of 25 years. I'm sorry, I was just reading it into the record. Apologies.
You're reading fast.
Scott alleges that the proposed mining will cause a substantial loss to grazing revenue over the course of 25 plus years. Mining and reclamation, as approximately 1,210 acres identified in the grazing lease will be without livestock water because 2 reservoirs will be disturbed. As a threshold matter, will there be 2 reservoirs disturbed by the proposal?
And our proposal is just the 1 reservoir.
And would that be rebuilt?
Yes, it would.
And approximately how long would it be out of commission?
We should be able to mine through that in 1 year and then get it to reclaim back the following year for water to fill up. So it'd be about 2 years.
Approximately how much water does that reservoir hold?
It's a fairly small reservoir. It's about a quarter acre in area size and probably a couple feet deep.
And the proposed reclamation reservoir?
We would propose to increase the water capacity and make a reservoir that would increase the water volume anywhere around 15 acre feet.
Okay.
15 acre feet.
And you testified at the beginning of this that you grew up on a ranch?
Yes, I did.
Are you comfortable testifying about some of these aspects with respect to his allegations, how this may impact grazing?
Yeah, I give you my opinion.
Do you believe that 1,210 acres will be removed from the grazing lands?
I do not, because the proposal is only 177 acres.
Will it remove 177 acres from the grazing land?
Not all at one time. It's over the course of the mining operation here, and it would be on average around 10 to 20 acres on an annual basis.
That were removed from grazing. And remind us, if you can remember, how many acres are covered by the grazing lease?
I believe it's 6,300 acres.
And again, how many will be removed?
What's that?
Again, how many will be
It would
removed?
be a total of 177 through the life of the mining operation on this property.
Okay, and then this is a continuation of Scott's allegation, but based on the removal of that one reservoir, he says that there's not water available in the general vicinity. Do you agree with that statement?
I do not agree. I believe there's several reservoirs located nearby, including ones that were recently created.
Recently created by whom?
By BPM on the Jolly Etzel claims.
And with respect to the state lease lands inside the permanent amendment boundary, are there additional resources of water that a cow could take advantage of?
Yes, we identified 4 reservoirs within the state lease boundary. Of the 4, just 1 would be disturbed by mining operations.
And do the others hold water?
Yes, they do.
And as part of the proposal, will you be improving this in any way?
Yes, we'll try to increase the water capacity of the other reservoirs, the one that we'll mine through. And then if one of the times I talked about cleaning out some of those reservoirs, we could try to enhance and clean those existing reservoirs that we would not mine through, but just we're mining nearby.
And did you agree to build any new reservoirs?
Yes, and we also agreed to build an additional new reservoir.
Okay. And what about outside the permit boundary? I mean, cows walk around. Is the permit boundary fenced?
No, it is not fenced. There's more reservoirs located just immediately outside of the permit boundary.
Okay, let's go ahead and take a look at what's been marked at BPM Exhibit 130.
BPM 130.
Tyler, do you recognize that map?
Yes, I do. It's a map outlining the surface ownership and as well as reservoirs located currently on the property.
Who created this map?
I would like to object to this because these reservoirs are south of the grazing area that will be impacted. The impacted grazing areas is north of those reservoirs. That's the whole issue here. The 1,200 some acres will be impacted because there's no reservoirs north of that. There are reservoirs south of that, but it's outside the distance where normally beef cattle will range to water.
Enough to overrule your objection, Mr. Erickson. The exhibit's already in.
Okay.
Go ahead.
Tyler, can you describe what we're looking at? And Joe, would you mind turning down the lights just for a minute? This should only take a few seconds. Can you please just describe what we're looking at?
Yeah, so what we're looking at is, again, similar map over the 2017 aerial. Tried to identify every reservoir on the property as well as stuff included inside the state lease 04 permanent amendment boundary right here.
Okay, let's go ahead and pull up what's been marked as BPM Exhibit 131. Tyler, can you describe what that, yeah, that's fine, Michelle, you can pull that up. Is that the Belle Fourche River?
Yes, so the Belfouche River runs around this area, mainly on the state of Wyoming lands.
And if I understand your testimony,
Yes.
It appears that Mr. Erickson has fallen off the phone.
Oh. Mr. Erickson, are you there? Okay. Just wait.
Mr. Erickson, are you there? Mr. Erickson?
It's just a couple of minutes before 11. I'm going to take a break for 10 minutes. That'll be enough time, everybody? So we'll wait, and Jim, when you get him back on, would you let him know? So we went ahead and took a break till 11:10. So.
Mr. Erickson, are you there?
Okay. Yes. All right, we're recessed until 11:10.
How do you go?
Sounds good.
We're not able to hear you, Mr. Erickson. We'll get back to you. If you want, go ahead and hang up and call back in about 10 minutes, 8 minutes. Thank you. No, they did. Well, you spill the whole thing. Everybody got that. Yeah.
You are the first participant on the Super Conference. Please hold while we wait for the others to join.
Right? Is he on?
Scott, can you hear me?
Yes, I can hear you.
Glad to have you back. Sorry about that interruption.
Okay, I thought we were taking a break or something.
We did.
Okay.
We just lost you there for a minute just before we, and so when we lost you, we quit and went on break. and came back.
No, hell no.
Okay, Mr. Exon, are you on the phone now again?
Yes, I am.
Okay, great.
Yes, I'm on the phone.
All right. If you need a break, tell me and we'll pause for a little bit. I have to admit that some of us took advantage of the phone difficulty to take a break. Are you okay proceeding right now?
Yes, sir, I am. Yes, I'm
Okay,
fine.
very good. Then we're back in session. Mr. Yannickin?
Mr. Tatro, I'll just remind you where we are. We're looking at an exhibit that you, I believe, just testified you put together. Can you again just quickly describe what we're looking at?
Yes, so this exhibit is similar to the last one. So we try to take in the concerns that cattle wouldn't travel more than half a mile to get a drink of water. So what we did is identified all those reservoirs based on the 2017 aerial imagery and put a half-mile buffer around them to see if it covered the grazing lands.
Did you put a half-mile buffer around the Belfast River?
I did not.
Is it your understanding that there is access to the Belfast River at certain increments along these lanes?
It is my understanding that yes, there would be access to that.
Okay. And based on your review,
Which exhibit is this?
Yeah, please repeat that. What's the number on the bottom?
131.
This is exhibit 131.
And Mr. Tatro, sorry.
Once I have an objection to this because the grazing lands also extend all the way up to the Four Horsemen. And that is, in some cases, 3 times the maximum distance. So the grazing lease, if you notice, includes 6,335 acres. It includes the northern Four Horsemen, which essentially is waterless for the most part of it. That's the problem here, guys. It's not just around the reservoirs on the 2U. There's no water beyond that.
I'm going to allow the exhibit to be in, to be received. I will overrule your objection, Mr. Aiken.
Okay.
Be brief.
Mr. Tatro, based on your review, is it your position that any of this acreage would be removed based on the removal of that single reservoir during the mining progression?
No, I don't believe so. We're going to remove one reservoir that'll be temporary out of placement for a couple of years, but I believe there's 3 other reservoirs within the permit boundary that will not be disturbed, as well as in the other reservoirs located adjacent to the permit boundary.
Are there reservoirs?
Yeah.
Could you show us on the map which one you're going to remove?
Sure. Absolutely.
Is there a better map for you for that?
I think you just zoom in, it should work.
That?
Yeah, and Michelle, if you want to just grab what's identified as the permit boundary for the amendment lands, Trailer, if you can, identify where those water resources are within the permit boundary and which one you intend to remove based on your mine proposal.
Okay, so you can see that this is our permit amendment boundary, the red and the yellow lines. There's 4 reservoirs. There's one located here, 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 and here. Only one that we will be disturbing that's in the mining sequence is this reservoir that's located down here.
Okay, and how far would you say that reservoir is from that big one further to the right and above it just a little bit?
This one right here? I would say that's probably close, probably about half a mile, would be my assumption on that.
Can you use a wall?
I obviously can't tell where he's pointing at, but all I can tell you is that all the northern reservoirs do not hold water. There is no water up north. That's been a recurring problem. That's why we rely so heavily on these reservoirs. You knock them out, in some cases.
That'll come up in cross.
Yeah, I think it'd be okay. Just Mr. Erickson, are you looking at this same exhibit?
I'm looking at, yes, the map for, I don't know, what did you call it? Exhibit 130 or whatever 15521 is. Has 4 horsemen. It had the mining boundary kind of in broken lines.
Yeah.
And it looks like it has kind of like green circles going around it. I think that's his half-mile boundaries, I guess.
Okay, very good.
So this is the largest reservoir in the amendment boundary, but we don't plan on disturbing that reservoir. It's outside the proposed disturbance.
Is he talking about the long reservoir by the Hall Road?
Yeah.
That's the last reservoir that holds water. If you look, you go all the way up to 4 Horsemen there. Basically, it is devoid of water. There are reservoirs which hold water.
All right, very good. Well, you can handle that. Go ahead. Thank you, Mr. Erickson. Go ahead, Mr. Hemmington.
Thank you. Tyler, based on your review, would any acreage be removed from the grazing lease as a result of removing that single reservoir in the middle of the mine progression?
As far as access to other areas, I don't believe that it would be. The only disturbance would be the disturbance from mining as far as taking away grazing use, which we reclaim on an annual basis.
To your knowledge, is there a fence or any obstruction that would prevent a cow from moving from, for example, the state lease lands to those reservoirs that you built on the Jolly Etzel claims?
I believe there's a fence located very on the south edge of the Jolly Etzel claim, but to the best of my knowledge, I believe those are still within the same pasture.
And when you provided the mine plan, the original mine plan to the Ericksons in January of 2016, did it identify removing this reservoir?
Yes, it did. It was in the proposed disturbance boundary.
And at what point did you understand the Ericksons had an objection to removing this reservoir?
I just recently found out when this was submitted.
From this document?
Yes.
Say that again. I didn't hear you.
Why don't you go ahead and repeat yourself?
You say what you just said, and then you say what you just said.
I recently found out when this document was submitted by 2U. It was the first that I became aware of it.
And just for clarification, 2U didn't object between the time in January 2016 when you provided that mine plan map that identified this reservoir being removed until last week when they submitted this to the EQC.
Yeah, their concerns were if we were going to mine through that to put a reservoir back and to build more reservoirs if we could.
And you agreed to those
And
requests?
pipelines.
Yes, we agreed to that request to build more reservoirs.
Very good. Okay.
We can turn the lights back up, Joe. Yeah, please. Let's talk real quickly, and I mean real quickly, with respect to the grazing lease that we've already looked at. Given your experience, how does that work? How do you determine how many cattle run on a grazing lease?
Typically, it's determined on an AUM basis. AUM is how much forage is needed to support a cow or a cow calf or bull, whatever you want to use for a standard month.
And how many AUMs does this lease purport to carry?
I believe that grazing lease said it was 375.
375 AUMs.
Yes, I believe so.
And doing that math in my head real quickly, 375 AUMs over 6,335 acres, I come up with approximately 18 acres per AUM.
Yes.
Does that sound about right?
Sounds about right.
And you've previously testified with respect to at any given time, and correct me if I misstate your testimony, but at any given time, the proposal would cause a disturbance over approximately 20 to 30 acres.
Agreed.
Is that right? And when I say 20 to 30 acres, these are acres that are no longer available for grazing until they're sort of released from reclamation. Is that
Yeah,
right?
till we remove fence boundaries. You know, it could stack up anywhere up to 40 acres at a time, but after you have enough growing seasons, we can remove those fences.
And based on your understanding of the grazing lease and the proposed mine expansion and reclamation schedules, how many AUMs would be lost with respect to your proposed operations for the state lease lands?
So based on those figures, it'd be anywhere from 1 to 2 maybe AUMs on an annual basis.
And can you just explain where you got that?
That would be just based upon if it's 18 acres per AUM, and we are disturbing up to 15 to 20 acres, just back calculating it that way.
Okay, and what's the price for AUM underneath the grazing lease?
I believe it's $30 per AUM.
Is that per year or per month?
That would be per month.
And given that price, rough calculation of how many dollars we're talking about?
Given that, it would be, so I guess that would come to about $60.
$60 a month.
Yeah, I believe so.
Thanks. Moving forward again real quickly, on the second page of what's been marked as 2U Exhibit 2, there's an allegation from Scott that these proposed mining and reclamation operations will substantially impact the hunting. Do you agree with that statement?
No, I do not, because we would adopt the same practices of stopping our operations during the deer hunting season like we've done in the past.
Okay, and again, what's your understanding of their hunting operation?
My understanding is that they have third-party hunters that come out. What we've noticed in the past, it's usually the month of November during the deer rifle season.
And in the past, you have pulled all your equipment out and stopped mining during the deer hunting season?
Yes, we have.
And at any point during your conversations with 2U, did they request the same for the proposed mining?
Yes,
And does BPM agree?
Yes, we're agreeable.
Again, they identify dust and noise. Anything you want to add to that?
We adopt the same practices that we're hauling out there. We'd be watering the roads during the hauling activities.
Looking at paragraphs 2 and 3 under hunting, there's a comment that there's anticipated expansion of hunting operations, planned lodges and cabins on these lands. Are you aware of that?
I'm not aware of any cabins on the property.
Are you aware of any plans to develop cabins or a tourism industry for the subject lands?
This is, I guess, the first time I became aware of it.
Okay. And lastly, with respect to trees, I know we've talked about this a little bit. Substantively, I want to avoid all that. Just briefly, based on the proposal, do you anticipate that number of trees would be disturbed by the mining operations?
No, I believe the actual amount of trees would be less than that.
And why do you believe that?
I believe that because, I guess for a couple things. First, that's our maximum disturbance. We would have that number would be reduced. So our when we start to move in, that's the areas that we would reduce would be along those trees areas, and it's based upon the density of tree density of the permit as a whole. So
what's based on the tree density?
The numbers of 10,000 trees. It's taking the number of acres that we had disturbed that's classified as woodland, based upon the density of the trees along the permit amendment boundary as a whole. The density area we're going to be disturbing, the woodland areas, is less than the density of other areas within the permit that have trees on them.
Okay, and why is that?
Because a majority of our mining operation will be conducting in the area where there's more of the open meadows. It's not as dense tree areas as other areas within the permit boundary.
And is that illustrated in the mine map?
Yeah, on the mine map and the aerials, you can see that the higher density tree area is located outside our disturbance area. I mean, there are trees within the proposed disturbance that would be disturbed, yes, but less.
Lastly, Mr. Tatro, again, revisiting the third element of this analysis, is it your position that the proposed surface use of these proposed mining and reclamation operations would substantially prohibit the grazing operations of 2U or its lessee?
I do not believe so. I believe that we tried to address all the needs, and I don't think it would prohibit it, let alone substantially prohibit it.
Same question, logging?
Yeah, same situation. We would not prohibit the logging operations.
Same question with the hunting operations.
Yes, we should not prohibit, or we would not prohibit anything with the hunting operations if we adopt the same practices like we agreed to do.
No further questions.
Okay, you're done. Mr. Erickson,
Yes.
and, do you have any questions for the witness?
Oh, yes, I would like to question you, yes.
Okay, it's your turn. Fire away.
Okay. Tyler, did we have a verbal agreement not to have money hunting during the month of November?
Do we have a verbal agreement?
Yes, did we have one?
Yeah, that was the request from you guys.
Okay. And what was the response after we requested that?
That we would not be mining during the hunting season.
Okay, why did our hunters find BPM moving their logging, their mining equipment back onto 2U land during the hunting season, month of November?
During the month of November?
Yeah. Why did Ronald Erickson have to call up your boss and tell them to get the mining equipment back off during the hunting season? Why did we have to do that if you agreed to not mine during the month of November?
I guess, so I'm not sure when that occurred. If that occurred recently, then yeah, we shouldn't have had the mining equipment in there. Was that just recently in 2016?
Yeah, now it's been, I think, 2 years ago. I'm not 100% sure on the time. I do know you removed your mining equipment, but once it was removed, our hunters caught you moving your mining equipment back in, unbeknownst to us. We had to telephone Joel Simmons and ask him to remove the mining equipment. You had a verbal agreement and you are going to obviously not impact our hunting. Why would you do that?
I guess the equipment probably got moved back in there sooner than it probably should have.
Yes. Is that showing negotiation and good faith?
Once they were operating off the verbal agreements that we have, and it was something that you guys requested, we tried to accommodate as much as possible off the verbal.
I'm going to object to the extent that this is beyond the witnesses. This is all speculation. He has no knowledge of this occurring.
It shows a negotiation and good faith or lack of.
Okay, I'm going to, I think, Mr. Erickson, before I roll on this objection, I'm going to actually say something and then ask you how much more you want to go down this particular line of questioning. The council's job, let me go ahead. The council's job in this particular hearing is to, first of all, reach a determination on those two items we said earlier, which is, does the plan, emphasis on the word plan, restore the land in a timely manner, and does the operation, plans for operation, will they not interfere with the existing uses? I think the line of questioning you're going down is, okay, at some point in time, the operator may have violated a verbal agreement that you had. Down the road, if in fact the DEQ issues a permit and conditions that permit such, then I think at that point, if they don't follow up or behave in accordance with your understanding of an agreement, you can then go to the DEQ at that point in time and they can decide whether or not to write a notice of violation. But your concerns about whether they will live up to an agreement that was verbal, it sounds like to be in nature, won't help us in terms of understanding the plan. The plan is much different than the execution. The execution of the plans come later and they're under the purview of the DEQ. So having said that, I'm going to ask you to, if you've got more to say along this particular line, be brief, and I'll hold the objection in abeyance for a moment.
Okay. My next question, Tyler. Are we under is reclamation basically under the approved permit of 267C?
There's some practice in there that we have proposed in the state lease as far as the mining schedule and reclamation schedule.
Okay. Does the reclamation plan has permit 267C and require that trees be replanted if the surface owner specifically requests restoration in writing?
Yes, there's some language in 267C about that.
And I would object to the extent Mr. Erickson misstates the permit. That the permit speaks for itself. To the extent he wants to visit that, we would propose that he looks at that language in the permit rather than trying to communicate it over the phone.
It's actually in exhibit, I guess you call it, That would be in 2U1, I believe, exhibit 2U1.
I'm gonna overrule the objection.
Page 154.
Yeah. Okay, you can continue, Mr. Erickson.
Okay. So permit 267C, reclamation plan section 2.11.8.6, post mining tree restoration, basically states that the reclamation plan text should detail tree replanting methods and locations. Tyler, is this included?
That is included in 267C.
No, but it needs to be included in the amended permit 267C reclamation plan. Is it included in there?
If it's spelled out in the proposed reclamation language of in the state lease 04 amendment, then it would be.
But is it? Is there tree restoration in the reclamation plan? My question.
Is the tree restoration in the reclamation plan?
Yeah.
No, no, it is not.
Well, again, I'm going to object to the extent that it confuses the permit. The permit amendment application adopts this language. It's clear in the permit, in both the mine plan and the rec plan that are attached and have been submitted to DEQ, that it expressly adopts the proposed the mining schedules and the reclamation schedules and the methods, including 211.8.6 that concerns tree restoration. We have proposed to adopt the identical standards that are in the the underlying permit. To the extent you want to, Mr. Erickson wants to confuse the record, I would just encourage you to revisit the text of the amendment.
So what exactly did it say?
It says that it adopts 2.11.8.6.
Which is what?
2.11.8.6 is
Can
a
I slow down? Repeat that number. I've not gotten it the whole time.
2.11.8.6 is a provision from Mine Permit 267C. It's entitled Post Mining Tree Restoration. And the Environmental Quality Act does not require a miner to replant trees.
So all that says it's not in there.
Well, no, I can provide more clarification. This is from the underlying permit. It says, and it's here, the permittee will not replant destroyed trees unless requested by the surface owner. That's a permit provision that BPM has agreed upon for all of its permit 267 lands.
But my question is pretty simple. Is there something in the mine? I think this is what Mr. Erickson is trying to say. Is there something in this mine plan today that says you will replant trees if requested by the surface owner?
No, there is not.
That's all that's if it doesn't, then it doesn't.
Okay, I think we can talk about it with the other witness, but I'm not sure that is completely accurate, but we can try to explain it.
So, Mr. Erickson, if it sounds like without putting words in your mouth, it sounds like you have received an answer to your question. So continue, please.
I can continue?
Yeah, go ahead.
Okay. This also, the way this is written, it says, this is required when the surface owner specifically requests restoration in writing. And we requested that via certified letter to BPM. You can find that on final exhibit 2U1, pages 100 to 101, and that's certified with return. We requested this. Yet it's still not in the reclamation plan as required.
Okay. Well taken. Please proceed.
Okay. Basically, Tyler, I have another question for you. Why does the restoration plan not follow the Wyoming statute 35-11-402A, which states reclamation must include revegetation of affected lands, including species be used, method of planting, and other details necessary to ensure the development of vegetative cover consistent with the surrounding terrain and the highest previous use standards set out. Now that includes trees. That's not just grazing. I understand you have grazing in the reclamation plan, but you have nothing about trees. Why don't you?
The trees weren't in there in the reclamation plan because when we initially proposed that wasn't an item that was requested by you guys back in January of 2016.
Okay, have you had an opportunity to amend that?
The reclamation plan, yeah, the permit hasn't been a process, so there's opportunity.
No, but couldn't you amend it and you've had several years to amend the reclamation plan to include trees. Why haven't you done it?
We haven't done that because we're looking with DEQ as far as what we should do and what should be required to reclaim this back to the best available. The request of putting back the same class, kind, and age, I don't believe would be the best practice, but that's why we have DEQ and LQD to review these reclamation plans to see what would be.
So basically, you're not following the law. Is that correct?
I'm going to object to the extent that he doesn't have the ability to speak to that. To the extent he believes that their permit has been proposed in accordance with the law, that's one thing. To testify that he complies with the law, that's DEQ's job. That's ultimately the EQC's job.
I'm going to accept that objection, Mr. Erickson, and really for the reasons stated, I'll be repetitive, but brief. That discussion should take place when the DEQ is reviewing the permit, and you'll have the chance to object at that time, and you'll have a chance to comment on the permit. So I'm accepting the objection.
Okay, well, my next question, Tyler, is, does the reclamation plan address DEQ, non-coal, Chapter 3, non-coal mine, environmental protection performance standards, revegetation? Basically, which states, reforestation shall be deemed to be complete when a reasonable population density as established in the reclamation plan has been achieved. The trees have shown themselves capable of continued growth for a minimum of 5 years following planting. And the understory vegetation is adequate to control erosion and is appropriate for land use goal. Plan should include the method and schedule of revegetation, including not limited to species of plants, seeding rates, seeding techniques, mulching requirements, and other erosion control techniques, and seeding times to be used in a given area for reclamation purposes. So is any of this included in the reclamation plan?
Our reclamation plan is outlined as far as what we've done in the past with grazing lands. To that extent, no, but I guess it'd be
no. This says reforestation. That means trees.
Again, I'm going to object. This is getting
far
into the substantive issues of this permit.
Yeah.
This is only a proposal.
I'm going to, Mr. Erickson, I'm sorry, but if I understand your line of questioning correctly, you're getting into the weeds, if you will, of a permit review, and this process isn't even to that stage yet. So I'm going to accept the objection, and I'm going to ask you if you can. I'll give you a chance here, though. Tell me, be specific. Would you please tell the council what point you're trying to make with that line of questioning as it relates to the two decisions we have to make today?
Okay. The way this adheres to the 2 points that the council is trying to make a decision on today is the council has had a precedent where they have basically previously ruled whether or not the lands have been restored to the highest previous use of defective lands. Okay. Well, how can the Environmental Quality Council do that if in a reclamation plan is lacking of any information that will allow them to determine whether the highest previous use can be achieved? It's going to be monitored by the TEQ in order to see whether or not the reclamation plan is adequate for tree planting. There has to be information in there. I think it's the Environmental Quality Council needs to make sure that this information is in the permit such that DEQ can go on and do their job.
Well,
Mr. Hearing Officer, may I have a,
yes, you may.
interrupt? There's been a lot of reference to law, been a lot of reference to EQC. We've done these things before, but I want to refer to 3511-406M, which states the requested permit, other than a surface coal mining permit, shall be granted if the applicant demonstrates that the application complies with the requirements of this act and all applicable federal and state laws. The director shall not deny a permit except for one or more of the following reasons. I want to jump down to reason XI. If information in the application or information obtained through the director's investigation shows that reclamation cannot be accomplished consistent with the purposes and provisions of this act. Now, this section comes after where we are now. The director and the DEQ will review the application, and per that item, if the director determines that reclamation cannot be accomplished, then he cannot grant the permit. So, these sorts of issues are important. That's why they're in the law. But we don't make that decision. We let the DEQ do its review. And at this point, we're trying to predict what it might be. And I think good points are being brought up, but I think I've heard a lot of these points repeatedly over the course of this hearing and the previous.
I would disagree, because if you look at La Fabia versus Environmental Quality Council in 1987, the Wyoming Environmental Council, under the Wyoming Environmental Quality Act, made a ruling. They made a ruling that land must be reclaimed to the highest previous use as mandated by the conclusions of law.
Mr. Erickson, what, if help me with this just a little bit. That particular case was not a case similar to where we are at now. That case
had previous use.
No. You're citing a decision made by the council that at a time and in circumstances that I believe are different than they are today. In the 87 case that you cite, a permit had already been issued. Is that correct?
Yeah, actually, I don't know that for a fact. I believe it.
Well, then if you don't know for sure, when you submitted some of that material to us over the last few weeks, I looked back on that, and that's my impression, is that in this particular case, we're not here today to evaluate how good or bad the mine permit is or how good or bad the reclamation might be. We are only here to make those two determinations that I have been repeating all morning. My belief is the case at 87, and I'm just going to say I don't, that does not, I'm just going to tell you what my impressions are, that does not apply now. And I think Mr. Bagley was pretty clear when he went to the statute and recited that part of the statute. So that one's, so I just have to say that your line of questioning is, I think I understand your concerns, but this is not the venue where those concerns can be addressed. So if you want to continue with your questioning of the witness, again, between the white lines, which are really the 2 points that we've got to decide today, please continue.
Okay. Well, it's basically, under my impression, is that a reclamation plan needs to basically include information that will allow the Environmental Quality Council to make a decision whether or not the approved future use of the surface will be restored to the highest previous use. So a question to Tyler is, what are the previous uses of the 2U?
Maybe, Mr. Erickson, let me just ask you if you could, Your question kind of talks about the highest, and let me just read what the statute says. The statute says the proposed plan reclaims the surface to its approved future use in segments if circumstances permit, as soon as feasibly possible. So it's approved future use is the phrase I just suggest you use.
True.
Okay, thank you. So go ahead and, if you would, and because I derailed you a little bit, would you please repeat your question for Mr. Dittrell?
I'd like to alter it some.
Okay.
Basically, if you look at Wyoming statute 3511-402AI, establishing the standards, states that reclamation should be the highest previous use of affected land, surrounding terrain and natural vegetation, surface and subsurface flowing or stationary bodies, wildlife and aquatic habitat and resources, and acceptable uses after reclamation, including the utility and capacity to reclaim land support such uses. So this would be beyond grazing. This would obviously be hunting. This would be viewscape. This would be habitat for hunting and so forth. So just the grazing is not the only approved use of the surface. That is just something that BPM came up with.
Okay. All right, I take that as a statement. And
let me rephrase that. Did you agree with that, Tyler?
With the previous uses, I would say would be the livestock, the wildlife uses, whether that's using the water there for livestock or wildlife to be determined, and then the logging that I don't know if it occurred on TDU, and then the hunting seasons. Is that line with what you're discussing?
Well, if you remove 11,000 some trees, would that interfere with recreational opportunities?
Objection, that misquotes his former testimony.
I'm sorry, I couldn't hear you.
Would it with recreational?
Hold on, Tyler. I'm objecting to the fact that misstates his previous testimony. There's been no foundation to establish that 11,000 trees are going to be disturbed. And it's also irrelevant.
Okay, I'm sorry, but you're gonna have to we're gonna have to rewind just a little bit here so that I can catch up. Do you have an objection?
Yes, just on the basis that it misquotes his misstates Tyler's previous testimony with respect to tree disturbance, and then to the point that he alleges that there's 11,000 trees to be disturbed. There's been no foundation, but in addition, it's just not relevant to the two elements that are still on the table.
The objection is sustained. So Mr. Erickson, do you proceed with your next question, please?
Yeah, I have yet another question here. Hold on, I just lost something on my computer. Tyler, how many trees will be disturbed by mining?
How many trees actually will be disturbed?
Yeah.
We won't know the actual numbers till we're in the mining process.
Did BPM submit a vegetative report which identified the number of trees they thought would be disturbed?
Yeah, in the vegetation report, it's derived from the tree density from the permit application as a whole, and comparing it to what they classified as woodland area in the proposed disturbance. They determine those acres to get a number.
Okay, so what was that number?
So that proposed number was around 10,000. It's not very much. 10,900 trees or something like that?
10,936. 7928 of Ponderosa Pines, 2460 Burrow, and 546 junipers. So are you saying that the vegetative report is wrong?
No, I'm not saying the vegetative report is wrong. It's based upon our proposed disturbance and the tree density as a permit as a whole. Or actual disturbance, we anticipate to be less.
Okay, so maybe you'll only disturb 9,000 trees, something along that general line?
Yes. Yeah.
There's no foundation for that. I have to object.
Mr. Erickson, what are you trying to drive at with?
I'm trying to drive at the fact is that in his previous testimony, that he said he did not know how many trees were going to be disturbed.
And
it's well established in the vegetative report.
So so can we move on? I'm not sure that if we get into a discussion about the number of trees, that's going to help this council make a decision.
Okay. Tyler, is there anything in the reclamation plan that addresses restoration of wetlands in the spring?
I guess my question is what do we define in wetlands here? Is it wetlands?
Well, I don't object. This is far beyond the scope of direct examination, and it again goes directly to substantive aspects of our both mine plan and reclamation plan, which are only proposals that have not been reviewed by DEQ.
Your last 3 words you said.
That our mine plan and rec plan are only proposals, have not been reviewed for compliance by DEQ. And that would include wetlands or springs or water, any aspect that's required under the Environmental Quality Act.
I'm going to overrule the objection and repeat your question, Mr. Erickson.
Actually, let's move on
Okay,
that.
very good.
Hold on a second here. Tyler, do you think that basically there might be a reduction in AUMs beyond what is actually going to be mined? Do you think that basically a reduction of water sources might impact basically cattle production?
Do I believe we're going to reduce the water
No, do you
capacity by reducing the AUMs?
AUMs due to a reduction of water?
I don't believe it will be reducing the water. Like I said, if we mine through the one reservoir, then we should be able to put it back in place and increase the water capacity like we've done in the past. So I don't think that would infringe on the AUMs.
You're assuming in arid Wyoming that you're going to get a gully washer and fill up this reservoir.
I'm assuming that there's not a lot of water production for the one reservoir.
I think, Mr. Erickson, the point you were trying to make about will the reservoir be disturbed and will they restore it? I think that point was made. I think questions that have to do with the vagaries of Wyoming weather are probably something we don't need to take into consideration.
Okay.
So please proceed.
Okay. Do you think, Tyler, that you can ever restore the land back to highest previous use?
With your permission. Mr. Erickson, I think I know where you're going, and as a landowner, I can understand your points of view, and you're making some valid points, just making them in the wrong arena. These are all things that you should bring back when it comes time to object to the permit itself and the petition for the mine. I mean, the tree issue, the water issue, those are all relevant issues and can be addressed in the mine permit itself. But you can ask the miners to haul water to the location of that reservoir if you so desire. And you can sure request them to plant trees in the reclamation, and I can't see any reason why they wouldn't do both. It's far cheaper than some of the alternatives. So the reason you keep getting overruled is you're in the wrong place. Your points are valid, but that's not why we're here today. You've got to figure out, and we're trying to leave you some latitude here because we know you're representing yourself, but at some point, we're going to have to cut you off and make sure you're in the right arena. And quite frankly, so far you haven't been. And we've got to get going on this. So as time goes on, patience starts getting short. So I'm just trying to tell you that. So maybe moving forward, you can limit your questions as to what's relevant to what the hearing officer has been trying to tell you and what becomes relevant later involving the mine permit and the reclamation itself. Does that make sense to you?
Okay. If you look at point E, it asks whether the proposed plan reclaims the surface to its approved future use as soon as feasibly possible. Tyler, can you ever return the land back to its approved use? Ever. Not feasibly possible, ever. That fits within D.
Yeah, that's a question for DEQ to answer based on the information we provided in our proposed plans.
Well, if trees are not included in the reclamation plan, can you ever feasibly ever reclaim those trees?
I'm going to object to, again, speculation, and we're getting down the same road we've been going down all morning.
The objection is sustained. Mr. Erickson.
I'm through with my questioning.
Very good. Oh, I'm sorry. Are you through?
Yes, I'm through questioning.
Okay, so it's now the council's turn. Council, do you have any questions for the witness?
Aye.
Oh, I'm sorry. Mr. Bagley. Or Dr. Bagley, please.
Thank you, Mr. Hearing Officer. I want to look at exhibit BPM 2.
And I chose this specifically because the date on the top I see is May 12, 2018. So this is, I think, about as current as we get. I just want to be sure this is the exhibit that shows the mine, sort of the sequence of mining that will occur and the lands that will occur on. Is that correct?
Correct.
Okay. So what does the yellow boundary represent?
That is the permit boundary for this amendment. It also corresponds with the Wyoming State lease minerals as well.
Okay. Is BPM going to mine that entire within that entire yellow boundary?
Not everything within the entire yellow boundary. Our disturbance is within the purple boundary.
So, if I heard correctly, the yellow boundary is approximately 600 acres total.
Mm-hmm. Correct.
But you will disturb up to 177 acres, and that's within the purple boundary.
Correct.
All right. Thank you. So to this question of trees, which I hate to bring it up because we've heard enough about trees, but I just want to be, I want to know, is the count of trees that you put into your vegetative report for the yellow boundary or for the purple boundary?
It includes everything within the yellow boundary. So when they're getting tree density, they look at the woodland communities as a whole within the yellow boundary. Then they define each different vegetation community.
I guess my question is rhetorical. Why didn't you count the trees in the purple boundary? I could probably do it on this map, but that's a rhetorical question. to Mr. Flitner's point earlier, a reservoirs are going to be removed. It does appear to be the case, at least from what we've seen. And do I understand correctly that you're during the mine and reclamation sequence, you feel that reservoir sort of down in the southern part, would be out of operation for a year or 2 years? How many years?
Yeah, we kind of figure about 2 years ago. It's located in one pit, so each one of these is kind of a rough pit cut that we would do. We feel like that we could make that reservoir within that exact same pit. So as we advance to the next one, then we would have to accommodate overburden somewhere else, and then have a reservoir left behind as we progress in mining. So I'm just going to estimate a year. 1 year we'd mine through it, and then another year for it to fill up if we didn't hit the timing of the precipitation correct at the same time.
So you figure 2 years, let's just say 2 years, that reservoir is out of commission. But after that, or, shortly after that, that reservoir would be available again for the grazing use. That's all.
Correct.
Okay. So during that time, and I defer to the rancher in this council, which we have two, but I don't know how far cattle will move or anything else to find water, but if they needed water, would you be able to bring water in? I mean, years ago I was in the military, we hauled water all over the place. Would there be an opportunity if that was necessary for BPM to haul water in to provide for the livestock?
Yeah, if that was necessary, if it was going to reduce the whole bunch of grazing down there, we could put up a temporary stock tank and make sure there's water available for cattle during the time that they're grazing that pasture.
So is that included in the plans at this point?
Hauling water it's not included in the plans at this point.
But it could be.
Yeah.
To a future plan as the plan's being developed, reviewed by DEQ.
Yes.
Thank you, Mr. Hearing Officer.
If it was, that was addressed sooner, we could have addressed it sooner in our initial plans as well.
Mr. Flitner? Yeah, there's been a lot of talk about these trees, and basically what we're here to decide is, comes up over and over again, can you put it back the way it was? So any reason for you to believe you can't grow trees after they've been taken out? Any reclamation experience in that area with any of those other mines? Did you ever run into a place where you couldn't replant trees?
We never had to put trees back, but based upon the data, we could have a DEQ review that, and if we feel that we could plant trees in there and be successful, I think it would. Knowing what I know about ponderosa pine trees and oak trees, they come back pretty strong after disturbance on their own.
Same way with water. No reason to believe you can't put water where it was before you showed up.
Yeah, based on past experience. Now we have more experience with that. We feel like we can put water back and even increase the capacity and volume of water.
Grass, everything else the same way. You haven't seen anything in any of this plan that tells you that you can't restore what you've disturbed.
No.
I would like to address that if I could. Basically, if you look at
Mr. Erickson, unfortunately, we're at that stage where if you got a comment there, if you can work it into your next at-bat, that would be okay. So, any Kath Lala?
I do, and I just want to be very clear. It's a little bit confusing. Trees. That seems to be the main objection. I want to make sure we're clear. Why, when you got the certified letter from Mr. Erickson, which is required in law, to move the planting trees into your reclamation plan?
Because
question, I could not hear any of that.
Sorry, I asked why, when you sent them a certified letter, which is required by law to include trees in the reclamation plan, did they know?
Okay, thank you.
So when we originally submitted this, it was in January of 2016. The request came in the fall of 2017. What we didn't think we could do is in the request, it wasn't just replanting trees, it was same age, class, kind, species. So if you take out a 20-foot pine tree, put in a 20-foot pine tree back, we don't think that that would be possible with reclamation practices and even be successful with that. It's something that we could do if we needed to put trees back in a different manner, and DEQ thought it was something that would be possible, then we put that in the reclamation plan or part of their request if needed. The recommendations, I guess I should say.
Okay, council. Ms. Blummer, are you on the phone still?
I am, and I can see the witness.
No more questions?
I don't have any questions. Thank you.
All right, thank you. Okay, Mr. Yemington, Mr. Michael, do you have any redirect?
No further questions for this witness.
Further? Very good. So, looks like you're off for a while.
Thank you.
Okay, everybody, it's 5 after 12, and Mr. Yemington, you all have another witness?
Yes, we have one more witness that we don't anticipate will take.
Yeah, and I will.
Less than an hour.
We've heard the council. Clearly, we're going to shorten that up as much as we can. Obviously, if you have questions, we want you to ask. We want to cover everything, but we understand the narrow scope of the hearing and want to get through it.
You know, an hour, I'm thinking that we need to take recess because of the council's obligation to be somewhere else. Council, would you agree with that? So, what I'm going to do is declare and Mr. Erickson,
Yes.
are you okay with where we're headed with this for a recess until 2 o'clock?
Yes, that would be fine.
Okay. I think that.
Till 2?
Yeah.
At 2 o'clock or 1?
Well, let's do 2 o'clock. Our meeting elsewhere is at 1:15 actually, and we got to drive over there and back. I think 2 o'clock would be the safest bet for having all the members of the council back online. Deb, I hope that's okay with you.
That's fine.
Hearing examiner, can we clarify
Yes.
Mountain
All right,
Standard
thank
Time?
you. Pardon?
Can we clarify Mountain Standard Time just for purposes of?
Yeah, so, good catch. So, Mr. Erickson, by our watch, it is 5 after 12, and we'll reconvene at 2 o'clock Mountain Standard Time.
So that'll be 3 o'clock Central Standard.
Yeah.
Okay.
Okay. Very good. Then this hearing is recessed until 2 p.m. Mountain Standard Time.
Okay.